Justices of the Appellate in the Supreme Court First Department. Hear ye, hear ye, all persons having business with the Appellate Division. Draw near, give your attendance, and ye shall be heard. Please take seats.
Good afternoon, everybody. Welcome to the Appellate Division First Department. Glad to see you here. I am going to read the calendar just for the record, but since a lot of the lawyers are obviously not sitting here in the courtroom, I am just going to read off the names of the cases, which ones are going to be argued, and how much time. Okay, People versus Fernando Rivera. The appellant has 6 minutes and 2 for rebuttal. The respondent has 6 minutes. Express Scripts versus MTA and Caremark. The appellant has 6 minutes and 2 for rebuttal. Respondent MTA has 6 minutes, and respondent Caremark has 5 minutes. Michelle B. versus Sonia D. is submitted. Dormitory Authority versus RLI Insurance is submitted. 5 Star versus Trustees of Colombia University. The appellant has 6 minutes and 2 for rebuttal. Respondent Colombia has 5 minutes, and respondent Lend-Lease has 5 minutes. Francois versus Department of Education is submitted. Gladstein versus Keane. The appellant has 6 minutes and 2 for rebuttal, and the respondent cross-appellant also has 6 minutes and 2 for rebuttal. People versus Rodriguez is submitted. Pavich versus Pavich. The appellant has 6 minutes and 2 for rebuttal. The respondent has 6 minutes. Slimish Corp versus Morgenthau. The appellant has 8 minutes and 2 for rebuttal. The respondent has 8 minutes. A. Semi is submitted. Belton versus Vernado Gunhill is submitted. Russo versus United Federation is submitted. Trinidad versus Turner Construction. The appellant has 7 minutes and 2 for rebuttal, and the respondent has 7 minutes. T. Page versus Kajo T is submitted. Jones versus New York Presbyterian Hospital. The appellant has 6 minutes and 2 for rebuttal. The respondent has 6 minutes. Committee for Environmentally Sound Development versus Amsterdam Avenue. The appellant Amsterdam Avenue has 7 minutes and 3 for rebuttal. The appellant New York City Board of Standards has 7 minutes and 3 for rebuttal. The petitioner respondents have 12 minutes. THTML versus Trust versus, for Architectural Easements is submitted. Hedges versus Plan Security. The appellant Plan Security has 7 minutes and 3 for rebuttal. The owner defendant appellants have 7 minutes and 3 for rebuttal, and the plaintiff respondent has 12 minutes. In the last case, NBC Universal versus Strausser is submitted. Okay, the first case for oral argument is People versus Fernando Rivera. You may proceed.
Good afternoon, Your Honors. My name is Jeannie Campbell Urban, and I represent the people of the state of New York in this case. Your Honors, reversal is required here because the 440 court vacated the defendant's guilty plea and sentence on a basis that the CPL did not authorize. Specifically, it vacated the defendant's plea and sentence upon a finding that the people's proof of one of the elements of second-degree burglary was lacking, specifically the element of contemporaneous intent.
So, Counselor, it's your argument that the court found that the defendant was innocent? Is that what you're saying?
I'm saying that I think that actual innocence is a shorthand for what we're trying to say, Your Honor.
Because wouldn't it be fair to say that actually what happened is what the court was really saying is that the plea wasn't voluntary because counsel did not advise his client to a possible defense?
Your Honor, respectfully, I don't think that that is a reasonable interpretation of what the court wrote in its written decision. I would specifically point you to the 4th and 5th paragraphs of the written decision, specifically the last 2 sentences of the decision, which say, "The record supports the defendant's assertion that he lacked the requisite intent for a burglary conviction. Therefore, his motion is granted." There is nothing about those 2 sentences that suggests that the court considered the defendant's voluntariness claim, which of course was rooted in a claim that his attorney had misadvised him. And not only that—
But wasn't that the claim being made by counsel in the motion?
It was, and it's our contention that there was error here because the court found in the defendant's favor, but not for the reasons that the defendant was asking. I would point out that in addition to the plain language of the court's decision, which I just read, there are no factual findings in the court's decision about what the defendant knew at the time of his guilty plea with respect to any possible defense or with respect to the elements of the crime.
Was there an affirmation from plea counsel?
No, Your Honor, and as we wrote in our brief, that in this circumstance was fatal to the defendant's claim that his attorney misadvised him and therefore he was unaware of something critical at the time he pled guilty. There was nothing in the record to support the defendant's assertion that he was misadvised and therefore didn't understand something critical at the time he pled guilty. The only support for that assertion in his 440 papers was his own say-so. And it is not proper for a 440 court to issue a summary grant of a 440 motion under those circumstances. It's CPL 440-30 subsection 3, which lists the requirements that the defendant has to meet in order to get a summary grant. And you can't get a summary grant unless your allegations are either conceded by the people, which was certainly not the case here, or were substantiated by unquestionable documentary proof. And there was nothing to support the allegations the defendant made about his lawyer's misadvice. I just wanted to go back to what I was beginning to say before, which is our position, obviously, is that the court issued a finding that was impermissible here, that the court made a factual finding as to the lack of a particular element of second-degree burglary, and that was not permissible in the context of a 440 motion. You know that that's what the court did here because that's what the court said in the second-to-last sentence of its decision. And the court, in the 4th paragraph of its decision, made factual findings with respect to the defendant's conduct in the hospital room. In other words, made factual findings with respect to the defendant's criminal conduct. That shows that what the judge was doing was issuing a factual finding with respect to his guilt or lack of guilt of the crime. And that was not permissible. You know that it's not a ruling on voluntariness because there are no factual findings in the court's decision with respect to what the defendant knew or did not know at the time he pled guilty. Nor are there any factual findings in the court's decision about what his lawyer's advice was. And of course, it wouldn't have been possible for the court to make such findings because there was no hearing in this case, and we don't know, other than on the defendant's say-so, what the lawyer's advice was. So, to conclude, my position is twofold. First, the court's decision was based on an impermissible ground, and reversal is required for that reason. But even if you disagree with me and you decide, you come to accept the defense position, which is that this was a voluntariness decision, the record really does not support that decision because there is nothing in the record that supported the defendant's contention that he was misadvised to the extent that he didn't.
How about the allocution? Is there anything in the allocution with respect to this issue being raised about intent?
Well, first I'll say that even the defendant in his 440 papers didn't ask for vacature based on the substance of the allocution. In fact, they specifically disclaimed.
No, I understand that,
argument.
but does it speak to the issue?
I don't think so, Your Honor. I mean, the judge read from the indictment at the beginning of the plea allocution, informed him of all of the elements of the crime, including the one that required, unlawfully entering or unlawfully remaining with intent to commit a crime therein. The defendant said nothing at the allocution that suggested a lack of knowledge with respect to that element. It's of course true that the defendant, the court didn't ask the defendant to admit that element specifically, but there's no there's no mandatory catechism for pleas anyway, so the fact that she didn't ask him that and he didn't say anything about it certainly isn't a reason to vacate, especially in the context of a 440 decision.
Thank you. You'll have 2 minutes for rebuttal.
Thank you.
Thank you, counsel. You may begin.
Good afternoon, Your Honors. May it please the Court. Ariel Reed of the Center for Appellate Litigation for Mr. Fernando Rivera. The prosecution is asking this court to overturn the motion court's reasoned decision based on arguments that they never made below and on grounds that weren't actually decided.
Is counsel correct that the court made a factual finding in this instance of innocence?
No, Your Honor. My adversary is not correct. In fact, my adversary chose to read the last two sentences of the court's decision, which are completely plucked out of context. If Your Honors will read the sentence before the sentences my adversary read, the court explicitly stated, based on the hearing testimony, the defendant's motion papers, and the court's failure to inquire about the intent element, the defendant's motion is granted. And I want to touch on each of those particular elements in the decision. So we know based on the hearing testimony that the complainant's story about what happened in this case supports my client's realization after he pleaded guilty and got a 12-to-life sentence as a 62-year-old man that he did not enter her hospital room with the intent to commit a crime. In Mr. Rivera's motion papers, he not only affirmed in a sworn affidavit that he did not know that that he had a possible defense to burglary, but I, as an officer of the court, called his plea counsel to ask about the decision-making behind letting him plead guilty to 12-to-life as a 62-year-old man, and I put the substance of that conversation in my motion. During that conversation...
So was that sufficient?
Yes, Your Honor. This court has repeatedly held that a sworn affidavit from plea counsel or counsel is not required in order to, recognizing, I think, that sometimes in these sorts of circumstances, counsels will, not be necessarily forthcoming about providing something in writing. In my conversation, which I affirmed in a sworn affidavit submitted in conjunction with this brief, counsel said that he thought that the evidence against Mr. Rivera was strong and that he thought that the contemporaneous intent element of burglary was satisfied because when the complainant asked Mr. Rivera to leave, he didn't leave. Now, that's just wrong. That's not the law of burglary. And I want to point out, in relation to the plea allocution, we are not alleging, in a 440 at least, because it's procedurally barred, that the court had the court was required to ask Mr. Rivera to allocute to intent. But we highlighted the plea allocution because in the plea allocution, the court asked Mr. Rivera, "You went to this hospital room?" And he said, "Yes." And then she said, "And while you were there, you took the complainant's phone?" And he said, "Yes." That's what he allocated to. That's not burglary. And so the plea allocution supports Mr. Rivera's claim in his affidavit that he did not know that he had any sort of defense to burglary, because if you take that definition, he admitted to doing those things. He didn't know that those things weren't burglary. And I just want to also note, Your Honors, that none of the arguments appellant here is making on appeal are actually preserved. None of them were made below. In response to our 440 motion, the prosecution argued, one, that Mr. Rivera's motion was procedurally barred because he didn't include a sworn affidavit from counsel. They said in the alternative that it was procedurally barred because he should have raised it on direct appeal. They said on his ineffective assistance of counsel claim that counsel wasn't ineffective because a 12-to-life sentence for a 62-year-old man is favorable. They said that counsel wasn't...
But counsel, didn't the defendant specifically say, and the judge wrote in her decision, that the defendant stated that he would not have pleaded guilty if he knew about this possibility? He made that statement to the court, no?
Yes, Your Honor. He included in his sworn affidavit a statement that he would not have pleaded guilty had he known that he had a possible defense to this charge. And I think it's important to highlight with respect to that even prior to his sentence on this case, Mr. Rivera asked to withdraw his plea. He said that he wanted to withdraw his plea. He wanted to either take the case to trial or to get a more reasonable offer from the people. The court actually appointed a different attorney to do a plea withdrawal motion for Mr. Rivera. That attorney said, I'm not filing anything because I don't think he should withdraw his plea. Mr. Rivera was seeking to get his plea back before he even knew that he had a reasonable defense to the burglary charge. So the idea that he would have pleaded guilty had he had this knowledge is illogical, because he was willing to go to trial without thinking he had a defense. And so I just want to note here that the court's decision, recognizing all of the factors that we highlighted in our motion, including my affirmation, including Mr. Rivera's sworn affidavit, including the plea colloquy, including the hearing testimony, which it doesn't establish that Mr. Rivera entered a hospital room with the intent to commit a crime. Based on that universe of factors, the court found that Mr. Rivera's plea was unknowing and involuntary, and nothing the people had put in their motion in response to that negates that. Their whole argument was that counsel didn't advise Mr. Rivera of a potential defense because there was no defense to be advised of. So the lower court disagreed with that. The lower court found that Mr. Rivera's claim is supported by the record. And all that means is that Mr. Rivera has a chance to go to trial. His case has been on the calendar since this was vacated, and he's been going to court just waiting for his day in trial. And that's all he's asking for, and that's all the court gave him.
Thank you very much, counsel.
Your Honors, just picking up on that sentence that Ms. Reed read from the court's decision, the court justified its decision based on the hearing testimony, the defendant's motion papers, and the plea allocution. And as I was saying before, even if you agree with the defense that this was a voluntariness decision, the record does not support that decision, and reversal is still required, or at the least you should be ordering a hearing on the defendant's claims. Certainly, the suppression hearing testimony has nothing to do with what the defendant knew or didn't know about possible defenses to burglary at the time he pled guilty. So it makes no sense for the court to say that the suppression hearing testimony supports the defendant's claim of involuntariness.
So in this case, your adversary says that she had a conversation with plea counsel and then reported the counsel in affidavit form. Why isn't that sufficient for the court then to review that to come to its decision?
Well, the conversation that counsel had with Mr. Morgan, the defense attorney who represented the defendant at the plea, in substance was Mr. Morgan saying that he believed that the people's evidence was strong and that he believed the people would be able to prove that the defendant harbored unlawful intent to commit a crime against the complainant at the time that she instructed him to leave. So there's no support for the contention that that was proof that he didn't know about the elements of burglary.
Intent at the time the defendant entered the hospital room?
I'm sorry, I didn't quite hear you.
What about the intent when the defendant entered the hospital room, not later when she asked him to leave?
I don't think that there's anything in the record about the defense attorney's beliefs about the people's proof on that issue. But if anything, that supports our position, which is that the defendant's claim that he was misadvised is not supported by anything else in the record. And for those reasons, we ask that you reverse or send the case back for a hearing on the defendant's claims. Thank you.
Okay, thank you both very much. The next case for argument will be Express Scripts versus Metropolitan Transit Authority and Caremark.
May it please the court, Carmine Castellano with the law firm of Hodgson Russ, counsel for petitioner appellant Express Scripts, Inc. Your Honors, this appeal is based on 3 simple points. First, the MTA's procurement of the PBM contract at issue in this case was governed by the All-Agency Service Contract Procurement Guidelines adopted on March 21st, 2018, because the PBM contract is a personal services contract, as that term is defined in the guidelines. Second, pursuant to the applicable service contract guidelines, when the MTA is selecting a third-party contractor and awarding a personal services contract, the MTA must comply with certain requirements in order to ensure that the selection process is fair and that it is open to the public.
Counsel, there was not a competitive bidding process here. Weren't two entities actually reviewed by the MTA, and then one of them was awarded the contract?
That's correct.
Why isn't that sufficient?
Because Your Honor, under the applicable service contract guidelines, they needed to invite 3 or more firms to participate in that selection process. Under the service contract guidelines, the MTA also needed to publish a 15-day notice in the New York State Court Reporter, which they failed to do.
Didn't they declare an emergency? And doesn't that obviate those requirements?
It does not, Your Honor.
Why not?
Because on January 14th, 2019, the MTA reached out to 2 firms, CVS and OptumRx. They invited them to participate in a private procurement process, okay? They didn't send out the 15-day notice. They didn't invite 3 or more firms to participate. They did not send the RFP or the notice to minority-owned or women-owned business enterprises.
Yes, again, I just have to sort of agree with my colleague with her question. How come the MTA didn't have the right to forego this competitive selection process if they were declaring an emergency, which they did?
The emergency was declared 2 months after they conducted a procurement process which violated the applicable service contract guidelines. So they went through this process for 2 months after they had violated the service contract guidelines. Then they declared an emergency. And then we need to look at the emergency, which was fiscal in nature and which was ongoing.
But
This was not an
don't the guidelines the guidelines do not, I believe, require that the emergency be declared before actually seeking the proposals.
That's correct, Your Honor, but you need to look at the nature of the emergency. What the guidelines do contemplate is an abrupt, catastrophic event which then allows the MTA not to follow the regular guidelines and immediately retain a contractor to resolve the issue which gave rise to the emergency in the first place.
Essentially, you're saying it has to be unforeseen and unanticipated. But is that what the guidelines say, actually?
They do not in the guidelines themselves. They do not.
Well, then why should we write that language into the guidelines?
Because then we are creating a blueprint for future public authorities and future benefit corporations to bypass these guidelines entirely and award contracts, billion-dollar contracts privately, and then after the fact declare an emergency based on their dire financial conditions, without having this process vetted and open in the public, and without having the public agencies comply with these competitive selection requirements.
Anything further?
Nothing further, Your Honors.
Okay, you'll have 2 minutes to respond to counsel. Thank you. MTA, are you going first? Okay.
Yes.
Okay, you may proceed.
Good morning, Your Honors. Max Schifrin on behalf of respondents, the Metropolitan Transportation Authority and the New York City Transit Authority. This appeal presents 2 straightforward questions for the court's consideration. The first is whether the MTA's emergency declaration, in the face of tens of millions of dollars in contract overpayments.
But it seems odd, doesn't it, that you have the right to go through a process which is not your normal process 2 months before you even declare the emergency. How does that work?
Well, Your Honor, first and foremost, neither the public authorities law nor the guidelines, as Your Honor pointed out in questioning my colleague, requires that sort of temporal limitation or requires an emergency declaration to precede any solicitations. Indeed, that would be completely at odds with the nature of emergencies, which often require quick transitions and quick action. That is exactly what happened here. The MTA and the NYCTA reached out to competitors. They requested solicitations. They requested proposals. They received proposals from CVS and Optum. And 2 months later, they declared an emergency before the board, and that is exactly what the public authorities law and the guidelines permit under these circumstances. Indeed, there is language in the public authorities law that contemplates this type of order of events. First of all, it says it says that in Public Authorities Section 4, it says that the MTA can summarize any negotiations that have been conducted once the issue is brought to the board, which itself implies that certain steps had been taken prior to the formal declaration of an emergency by the board. Your Honor, again, the two issues before the court are whether the emergency declaration was rational, and that inquiry, as this court is aware, is governed by a highly deferential standard under Article 78. It's a rational basis standard. And the second question is whether any discovery was necessary in this case in order to resolve that highly deferential inquiry. And I think what my opponent is essentially asking this court to adopt here is a strict scrutiny standard, one that involves probing the details of the MTA's emergency procurement itself, not the declaration of an emergency, but the emergency procurement itself. And that is completely irrelevant under the public authorities law. It is completely irrelevant under the service guidelines that apply here. And thus, this court should simply affirm the court's judgment, which was based on an adequate record, a record that included a board resolution that stated there were millions of dollars in contract cost overruns, that the MTA's dire financial condition at the time was exacerbated by those contract cost overruns, and also the affidavit of David Ross, who was the chief procurement officer at the time, which further explained that these contract cost overruns were the result of contract mismanagement by Express Scripts. Under these circumstances, given
Was the emergency the general problem with money, or was it the alleged fraudulent activity relating to the compound medications, or was it both?
The emergency was all of the above, Your Honor, but ultimately the dire financial condition that existed at the time. We all know that the dire financial condition is considerably worse now, but in 2019, the situation was already dire, and that dire financial condition was exacerbated by the tens of millions of dollars in contract cost overruns that were the result of Express Scripts contract
So if we
mismanagement.
accept your position that it's the dire financial circumstances, which, as you said, we all know are exacerbated today, does that mean that the MTA can do this with any contract that they have?
No, Your Honor. The issue, if there's a dire financial condition and if there is a contractor that exceeds projections by tens of millions of dollars as a direct result of contract mismanagement, then that can absolutely create an emergency.
That's a judgment that's made independently of the dire financial circumstances. So the dire financial circumstances as an emergency applies now across the board to everything that the MTA has.
Well, no, Your Honor, I think...
Really, right?
No, I think under the board resolution, it was a mix of multiple things. One was the dire financial condition, which is unfortunately an almost permanent state of affairs at the MTA. The second was the tens of millions of dollars in contract cost overruns that took place under this specific contract. And the third was that it was...
MTA has some other contracts with other suppliers that they assess are inappropriately high. Then this financial situation that we have gives them the opportunity to set aside those contracts and make contracts with other providers.
Well, Your Honor,
across the board.
The MTA is not looking for reasons to obviate and go around the public authorities law. But
That's not the legal issue here. I'm not imputing bad motives to anybody, okay? I'm not saying they're an evil bunch. I'm just trying to understand your legal argument and the implications that it would have.
I understand, Your Honor, and I appreciate the question. Ultimately, if there are dire financial conditions and substantial cost overruns of the kind that existed on this specific contract, that can absolutely form the basis, a rational basis, for an emergency transition to a new contractor in order to save the taxpayers tens of millions of dollars in overruns. Thank you very much.
Thank you very much. Okay, counsel, you may begin.
Good afternoon, Your Honors. Robert Scher from Foley and Lardner on behalf of CVS. CVS is the company that put in a bid. Its bid was accepted and is currently the contracting party. Not surprisingly, there isn't a single allegation against my client in the petition. So unless you have any questions for me, I don't have anything to add to the argument. Thank you very much.
Anyone have questions? Okay, well, thank you very much.
Just a few additional points, Your Honors. Counsel for the authorities referenced the public authorities law. Without a section, I believe he's quoting from section 1265A. That is inapplicable to the PBM contract at issue in this case. I'll go back to my first point, which is that the PBM contract is what is defined as a personal services contract for highly technical, specialized skills. And so under the definitions set forth under the guidelines, the all-agency service contract procurement guidelines apply, not the public authority law, section 1265A, nor the general contract guidelines. That needs to be clear. Again, I'm going to go back to the undisputed facts in this case. On January 14th, 2019, the MTA contacted two companies, Optum and CVS, to participate in a private procurement process for a $1 billion contract. At no time did the MTA invite a third company to join that process, which they were required to do under the applicable service contract guidelines. At no time did the MTA publish a 15-day notice in the New York State Court Reporter, which is also required by the applicable service contract guidelines. And at no time did the MTA serve the RFP or the 15-day notice on minority-owned or women-owned business enterprises or businesses owned by disabled.
Counsel, isn't the issue that the cost overruns of the ESI contract created an emergency situation? Isn't that the issue, the core issue we're dealing with here?
Well, Your Honor, that's not the issue. I think the issue is, what do the guidelines contemplate as an emergency, which allows the MTA to then disregard the requirements for a competitive selection process?
Well, running out of money seems to be an emergency to me.
But it's an ongoing problem, Your Honor. So what is the catastrophic, abrupt event that made the MTA go out and have a 2-month-long process with two other companies in private before they declared the emergency?
But I thought that the guidelines don't require that the emergency be unforeseen or sudden, just like it doesn't require the emergency to be declared prior to the actual competitive procedure.
Again, Your Honor, not expressly. However, if that is the case, then they can call an emergency whenever they want, have an improper selection process, and then declare an emergency and a winner of that improper private procurement process.
Okay, thank you. Thank you all. We will take a look at this
Thank you, Your Honors.
further. Thank you. The next case for oral argument will be 5 Star Electric versus Trustees of Colombia. Good afternoon.
May it please the court, my name is Andrew Richards. I'm the attorney here for the plaintiff appellant 5 Star Electric. I've been here a couple of times in the last few months with delay claim cases, and I've had Justice Kennedy twice and Justice Singh, you were the last one I had on a case called Federated 56 Leonard Street. In that situation, the court upheld the lower court's decision on a motion to dismiss. What is important here is every construction case is different. The facts are different. The reasons for delays are all different, and we can't just simply lump all cases to say either they meet a Carina Civetta exception or not.
But let's go to this case. You know, I was on WDF. How are your allegations substantially different from those made by the HVAIC subcontractor in WDF? How are the allegations here, your allegations, different from the allegations made by the HVAIC subcontractor in WDF?
On the same project?
Yes.
Very simple. My client, and the contract is clear, is the core and shell electrical subcontractor. It is clear the essence of the deal in this contract was that they would be doing the core and shell, meaning the outside of the building and the guts, not the fit-out work like WDF. We were supposed to be in there, unfettered, except for one mechanical contractor doing core and shell work as well. We were not supposed to be doing the work while the 15 other fit-out trade contractors were doing their work as well. It completely changes the bid my client gave them to do the work. And what we're talking about here is we keep saying there's every contract, the delay, no damage to delay clauses say we can order out of sequence work, you can't get claims for productivity. But at what point, the general contractor or owner cannot simply have carte blanche to change anything they want in the deal. What is supposed to happen? Should we double the price of the contracts to think this is going to happen? It can't be. We were supposed to be almost gone by the time WDF and the other fit-out trade.
Essentially, it's your inability to be working alone, so to speak. That's the difference?
It's a big difference, yes, but that's what it says in the contract. We gave a price. There's a scope of work that says it. It's detailed. This is a negotiated bargain between two parties.
But yes, it is. But isn't also you have in your Article 12 of your contract, which has the no damages for delay provision, that is pretty extensive about what you are not entitled to sue them for.
Your Honor,
I mean, I understand what you're saying about the delay and not being able to work alone like you thought you were going to, given what you were doing. But still, isn't that what you agreed, those kinds of damages that you agreed to waive under the subcontract?
no. And what's very important, and I've said it before, is these no damage for delay clauses are very, very general in nature. They don't spell out, you may find, we need to get approvals from the MTA or other governmental entities, and if we don't get them, you may be delayed. That is something we would know about. That was in the Bovis case versus Lower Manhattan Corp. That's cited by my opponent. And there's a specific a potential cause of delay that's laid out. If we read these generic boilerplate, general no damage or delay clauses to prevent a claim such as this one, this court will never, ever find that a complaint passes the muster. And this court, what's happening now is basically has deleted the applicability of the exceptions to Carino and Civetta. There are none. If this case can't pass muster...
Didn't this court say in the WDF case that if you could show... Can you hear me? Didn't this court say in the WDF case that if you could show bad faith, willfulness, malicious, or grossly negligent conduct, then the clause would be obviated?
Yes, but the point is, at what point do you determine whether the evidence shows bad faith or not?
But the real point, and it's one that I have never understood, why do your clients agree to these contracts? Why don't they have someone redraft these contracts? Why don't they renegotiate this aspect of the contract? Because you are not far off the mark. That is very, very difficult.
Your
for you
Honor,
to overcome the provisions that exist in these contracts.
I understand what you're saying, Justice Mazzarelli, and I've argued many times of construction cases before you when you were a lower court judge. And the truth of the matter is,
You haven't argued any since I've been here?
I'm sorry?
You haven't argued any in front of me since I've been here?
Yes, you hurt me on the Federated versus Excel West 57th Street. You were on that one with Justice Kennedy. I think that was Justice Kennedy's first day on the bench, I believe, here. So I've got the same judge. As I walked in, I said, oh boy, this isn't going to be so easy today.
But the fact is that we actually have so many of these cases. You're not incorrect. We have a lot of these cases about delays and no damages for delay provision, which is something that was added to these contracts maybe 10 years ago. Or it wasn't always there.
Right. And for some reason, the first department, unlike the second and third departments, we can't get past the pleading stage. And I want to answer your question, if I may.
All right, why don't you just
The truth
ask
of the
her
matter
question?
is, to answer your question is, I'm a lawyer. We're lawyers in this room. The people who do these contracts are business people, okay? They want to do business. And quite frankly, there's no way that a subcontractor can get a no damage for delay clause out of the contract. That's just reality. That's the practicality of business. And that's why the Carino Civetta creates the exceptions, because at some point, actions become so egregious that a trier of fact has to determine whether they supersede a garden variety delay, poor planning. At some point, they have to exceed it. Otherwise, there are no exceptions to the no damage for delay clause.
Okay, you'll have a little time to respond to the defendant respondents, okay?
Thank you, Your Honors.
Thank you very much. Who is going to go first? Colombia?
Yes, Your Honor.
Okay, great. Sure.
Good afternoon, Your Honors. James Terry of Zetlin and De Chiara, LLP, for the Trustees of Colombia. Your Honors, the motion court scrupulously adhered to the jurisprudence established by this court in granting these dismissals. That goes from the LaDuca and 2013 Bovis decisions through the two affirmances in WDF, which, by the way, is 5 Star's affiliate company, and continuing on to this year, to the 2 federated decisions to which Mr. Richards made reference, both of which cited WDF, both of which unanimously upheld the dismissal of the claims pursuant to the no damage for delay clause. Now, many of the alleged delays...
What does the plaintiff have to allege here in order to at least get past the pleading stage on these no damages for delay? Because certainly there were things that were not anticipated, but what do they have to allege?
They have to establish one of allegations that rise to the level of a Carino exception. All of these issues concerning the access to the property, all have been unanimously resolved as inept administration, poor planning of a project. I mean, there is the exception for fundamental contractual obligations that are express. So if they wanted to have an express obligation of, for example, a critical path method schedule, that's what could be put into the contract. If that's violated, that becomes something that becomes actionable. But the allegations that were before the motion court did not rise in any shape to that level. 5 Star recently made exactly the same arguments before Justice Sherwood, and they were rejected, both no damage for delay and the cardinal change in 5 Star versus Plaza Construction, which was reported rather after our brief was prepared. The site is 2020 Westlaw 446-4334, decided this year. Pretty much exactly the same allegations were made and were rejected. The question was asked, how does this case differ from WDF? Your Honor asked that question. The answer is really not much at all. The allegations are very similar. Some of the delays are exactly the
But
same.
isn't counsel correct that his client is a core and shell subcontractor and is entitled to be doing his work alone? would that be sufficient to say, to bring it
No,
within
Your
the
Honor, that's
exception?
really a distinction without a meaningful difference. Both of those companies had work, defined scopes of work to be done within a certain period of time. Both were delayed. If you take the argument that's been made by the appellant and carry it out, then the only party against whom a no damage for delay clause could be applied is the last trade on the line of progression. Because every other trade could say, well, I never expected to have to work with those follow-on trades. And that would basically render the entire no damage for delay clause useless. The fact of the matter is that they had exactly the same delays in many respects: late superstructure completion, the need to replace the concrete flooring, causing them delays, the absence of the critical path method schedule, causing them delays. Some of them are exactly the same, others similar. With respect to the negotiation of this contract, this was a negotiated contract. The contract does have a rider, and the rider amended not only the no damage for delay clause, but other provisions of the agreement.
So, plaintiff did allege in the fifth cause of action that because of this delay, there had to be resequencing of the core and shell work, and that this, at least they allege, drastically changed the nature of their original scope of work. Is that enough?
No, Your Honor, because it doesn't.
Why not?
No, because the cardinal change test is the essential identity, the main purpose of the work changed. And that didn't happen here.
Well, what would constitute an essential change of the work? I mean, they're there to do the kind of work they're going to do. They're not going to become a different kind of contractor
No, but
overnight.
if you tell a core and shell contractor, I want you to take on the fit-out work, that's something very different. If you tell a contractor, we originally thought this was going to be a 6-story building, it's going to be a 9-story building, we want you to stay to your contract terms for that, that would be considered a cardinal change. But the motion court correctly found that what was alleged here did not change the essential nature of the contract. That's why it was capable of being subsumed within Article 13, the changes clause. The analysis was scrupulously made and it was correct.
Okay, thank you very much. Counsel, we'll hear from the attorney for Lend-Lease.
I appreciate your time. Thank you, Your Honor.
Certainly.
May it please the court, my name is Lauren Donnelly, and I represent Lend-Lease in this case. The lower court properly dismissed the claims that the delay damage claims asserted by 5 Star and the cardinal change claims. The question was posed as to whether the fact that 5 Star was a core and shell contractor as opposed to another type of subcontractor, whether that makes a difference. It makes absolutely no difference. And in the case E.E. Cruz, Nicholson Joint Venture, Lend-Lease, it's a Supreme Court New York County case, plaintiff was retained to perform almost identical work that 5 Star was required to perform in this case. And there, the court dismissed the delay claims based upon a similarly worded Article 12. And in this particular case, Article 12 sets forth specific reasons for, or conditions or conduct where they cannot collect delay damage claims. That is increased labor, material costs, hindrances or obstructions or delays, ordering changes, corrections, whether they were foreseeable or unforeseeable or contemplated, and whether the delays were fault of the contractor, owners, architects, and separate subcontractors. So design delays are even part of this Article 16, and Article 12, I'm sorry. The subcontractors conclusively established that the damages sought by 5 Star were barred by the subcontract, and none of the Carino exceptions exist.
Can I focus you on the first cause of action where at least the branch of the first cause of action relating to design errors and omissions, was that properly dismissed? I mean, isn't the first cause of action essentially seeking money for change orders?
Well, the first cause of action does seek that, but nevertheless, it incorporates each and every allegation of the prior paragraphs. And in paragraph 106, it specifically alleges that all of the above, which includes the design errors and omissions, caused Five Star to be materially delayed in the performance of its work and in timely completion of the
They're not seeking delay damages there, right? Aren't they just seeking damages for extra work?
Well, is part of the delay damage claims.
You believe the first cause of action is seeking damages for delay?
Yes, as part of that as well, yes. And in terms of the cardinal change, the fact that they were required to perform additional work is contemplated by the contract as extra work. It did not change the essence or identity of this particular contract, and therefore,
Aren't they able to recover for extra work? Isn't that something different than a delay?
extra work? Yes, they're
That's-
barred by the provisions of extra work. Yes, yes. And in addition to that, there's no gross negligence here. All of the allegations are basically inept administration or poor planning, and there was no breach of any fundamental obligation under the contract. So if there's any other no other questions, I'll rest on my brief.
Thank you very much.
Counsel, could you address that first cause of action that we were asking questions about?
The first cause of action doesn't mention delays. I don't even know how to.
What are you seeking in the first cause of action?
Extra work caused, extra scope of work performed due to design changes. It happens all the time. It has nothing to do with delays. It's extra work we had to perform. Different work, more intense, whatever. It's extra work. It's not a delay damage. Delay claims and delay damage is not necessarily synonymous. Did that answer your question?
You're not seeking damages for delays in the first cause of action.
We are
You're just
not.
seeking-
We are not.
You're
I don't
just
even know
seeking
how
monies
the
for
lower
extra
court
work.
got there, but that's neither here nor there.
Thank you.
You don't use the word delays even in the first cause of action.
No, I think I wrote that in my brief. I read it again. There's no word of delay in there.
Okay.
May I move on, or do you want me to
Good.
continue with it? Okay. Addressing counsel for Colombia. I'm sorry, I forgot which judge asked the question, but the first question was, what does Five Star have to allege to establish an exception? Every time that question gets asked, with the 3 times I've been here, no one has an answer. You can't just say you have to establish gross negligence. What does that mean? What facts have to be established? In other words, what facts does someone have to plead that would be in a notice pleading state? We're not in a summary judgment here. A notice pleading state to get to even give notice of the type of facts that would be the exception, and that's done here. It's not a conclusory statement where we were delayed and we have damages. That would be thrown out in a heartbeat. I get it. But
So, counsel, so what is the exception or exceptions, and then what are the specific allegations that you indicate support those exceptions? What are they?
Okay, well, now you're getting.
Yeah, let's go.
Okay.
Thank you.
Changing when we're doing the work, as opposed to doing core and shell work before the fit-outs come in, doing it at the same time. We had to do more BIM, building information modeling work. There was stacking of trades. That was not the essence of it. There was the problem with the, I'm sorry, I didn't bring my reading glasses. The sub-metering design. Rejection of submittals without even helping us, telling us why they're rejecting them. What are we supposed to do? How do we fix that? You have the failure to provide information for short-circuit study. In the contract, they had an obligation to give us information so we could do the short-circuit study. They didn't do it. At some point, people have to be responsible for the obligations they have under a contract. And they can't just say, okay, here's a contract. It's 85 pages, probably more here, with very specified scope of work and who has obligations, and then turn around and say, hey, we don't have to do that anymore. You'll work this day, that day, that day. That can't be the case here. It can't be.
Okay. Thank you very much. We'll take another look at your papers. Thank you all very much for
Thank you,
coming
Your Honors. Have a
today.
nice day.
You too.
The next case will be Gladstein versus Keane.
Good afternoon.
Good afternoon.
My name is Tom Keane. I'm the defendant pro se and also attorney for my wife, Susan Keane. The promissory note that I signed was modified by an agreement that we made in Mo Motz's cubicle, Harvey and I, after it came to both of our attentions that Harvey had taken more money than he was entitled to under both the employment agreement and the purchase agreement. That being the case, the promissory note was never put into default. It was never properly accelerated. What we needed to do, when Harvey knew what we needed to do, was to find out what was the amount of the offset. And I can say he knew what he needed to do because he actually got a different accountant. He was unhappy with the accountant he had for more than 40 years because of the result, showing that he had taken, at that point, based upon the records, approximately $130,000 more in year one and year two than the agreements required because he had made a mistake.
Counsel, what is the evidence that the parties entered into a set-off agreement? What is the evidence of that?
The evidence is my testimony as to the set-off agreement, which was deemed credible by Judge Schechter, but also Harvey himself said, I don't know for a fact that that agreement didn't happen, and that's at page 370. Earlier, he said, well, when Mark told me that there was a little bit of money that I was ahead, I said that we'll straighten it out at the end. So that was Harvey's testimony and Harvey's idea that it be an offset. And Judge Kennedy, it makes sense because I was not going to tell Harvey, you got to write me a check today for $130,000, even though I already owe you money that you loaned me. That wasn't our relationship.
Now, I know that there was different testimony regarding that. So because there was differing versions, didn't the court have the right to credit the other version that it didn't exist?
Well, Judge Kennedy, the court had, what the lower court found was that the agreement did exist. What she also found, though, after she did math and made some deductions, was that I had paid $445,000 out of $450,000 that was owed for the purchase, which was $50,000 a year, and the $100,000 of perks a year. And she did that by disallowing certain things that, for example, the FICA. The FICA, it was proven that the employer paid its side of the FICA. There was testimony as to that, and it was actually in the...
Was that the testimony by your office manager?
No, Your Honor, it's the testimony of Mark Rossman, who was both Harvey's accountant and the firm's accountant. And he testified, at page 816 of the record, that this is how it works. And his formula is actually found at page 17, 20, and 21 of the record, where he actually wrote out on the sheet of paper that FICA is 7.XX% of the $39,000 that Harvey and Marlon were being paid annually. It's actually on those pages, $7,779 times 3 is $23,337. That's in the record, as clear as can be in this record. So that's one of the offsets that she should have allowed. And that offset by itself takes Harvey into the area where he took more money than he was supposed to. The health insurance was proven. Judge Schechter was going away, so she gave us a 15-minute time limit. And I knew that the box that I had under my desk would not get in. If you've read the record, you've seen that everything was voir dired extensively. So I went with Margie's 30%, which I knew was less, and it turned out it was less. It was 39%. So the firm paid, as a perk to Harvey, an additional $22,721. The firm paid to store Harvey's old cases, most of which were already over 7 years old when I got there. The firm paid $24,265,000, which I found out when it was in collections and they were suing me. So I paid it. But that was Harvey's. And Harvey actually admits that it was Harvey's if it was more than 7 years old. 81% of those files were more than 7 years old, and even the ones that weren't, it's a liability of the old firm, not of the new firm. So Judge Kennedy, that's a long way to answer your question. But Judge Schechter actually did find that that's what happened. Harvey and I met in Mo Moss's cubicle and agreed at the end of our agreement, the promissory note will be offset by the amounts Harvey took above and beyond. And at that time, we had no reason to believe it was anything less than $130,000 already, with still more to come. I'm not done? Okay.
Well, yeah, have it like a few more seconds, so if you want, you can say, you know.
I'll say that. Thank you, Your Honor.
Okay, thank you very much.
Good afternoon, Your Honor. My name is Lawrence Rosenstock, counsel for Harvey Gladstein. I also want to thank the court for allowing us to appear in person today to make our argument, and I know it's a difficult time.
Mr. Rosenstock, how do you respond to your adversary's position that the note wasn't accelerated?
The note clearly was accelerated because there was an acceleration letter that was sent to both Mr. Keane and his wife, and there's several case laws that say that when the case was initiated by the filing of a summons with notice and a summons and complaint thereafter, that alone would deem the case accelerated. There's cases in this department, actually, that uphold that idea. Plus, the fact is that notice was given when Mr. Gladstein said he was going to retire. I think it's clear that oral notice alone was sufficient, but in any event, as the trial court, and I think Justice Keane had held, when Mr. Keane received notice that Harvey was retiring, they actually paid a check of $6,000 to Mr. Gladstein. That was the first loan repayment. So they clearly considered that the loan was due. Thereafter, Mr. Keane decided that he didn't really want to pay the rest of it, so he came up with, well, I think the record will show, a whole series of bogus claims, many of them really impossible. In one instance, he even...
And was the failure, I believe the defendant did not make a payment after that first payment after your client retired, and so did that automatically justify an acceleration of the full note?
It did, and we did send a letter out, of course, accelerating it to both parties thereafter. So once he made the first payment, and didn't make any other payments, and their demands were made, then they sent a letter out demanding that further payments be made. There was no response. Nobody claimed anything. And then after the default continued for 3 months, the lawsuit started, and then that's a further written demand that payment be made. So I think as a matter of law, there clearly was acceleration, and there clearly was notice given to everybody. So I don't think that that is a valid claim. It's just a technical claim trying to avoid the obligations. It's really interesting to note that Mr. Gladstein lent this $180,000 because Mr. Keane needed additional money. He gave it to him in 2012. It was interest-free, and the note wasn't even, no payments were due until 2014, 2.5 years later, and even then, without interest, Mr. Gladstein was willing to accept $6,000 per payment per month over 30 months. So he was more than generous in trying to provide Mr. Keane with money. And in response, what he got were claims that, well, I don't really owe the money, there are other offsets, and all the records show there were no offsets. In fact, I think that...
You know, my colleague asked that question of your adversary.
Okay.
Didn't the trial court essentially hear the testimony of the witnesses and find that there were set-offs or offsets in favor of the defendant? Aren't we sort of bound by that, the credibility determinations of the court?
Well, we did cross appeal as to certain findings. For instance, and one of the problems was that, and it's both parties' fault, I guess, but nobody ordered the transcript. And so one of the biggest offsets that the court did not address, but was in favor of Mr. Gladstein, was the fact that there were records by the bookkeeper that showed that after this buyout occurred, Mr. Gladstein was entitled to receive a any income that came in or any fees that were served that the firm received for work in process or that were billed or unbilled. And the bookkeeper's own record shows that over $400,000 of fees that belonged to Mr. Gladstein were commingled in Mr. Keane's firm account and used to pay firm expenses, including, by the way, expenses that even Mr. Gladstein was entitled to receive. So I think in large part these records demonstrate that Mr. Gladstein was being paid with his own money to a certain extent. But that's over $250,000 even aside from the note that's due. And so clearly that by itself would make any set-off claim nonsensical or unenforceable. Plus the fact is that when you really look at the actual record of the testimony concerning the alleged set-off agreement, all Mr. Gladstein said was that when he was told that there were so-called overpayments, he said, well, I'll have to look at it. He said he'd consider it. He never made any agreement. In fact, he never agreed to anything because he never agreed to the amounts. And I think this is confirmed by the fact that as soon as he retired, he made a demand for payment and it was actually paid. This is not the conduct of somebody who entered into some agreement to consider what else might be offset over what was owed to him. He always believed, and I think the record demonstrates, that he was never overpaid any amount. In fact, several $100,000 of funds were commingled that belonged to him and were used to pay the expenses of Keane's law firm. Additionally, I think the trial court was in error in saying that the petty cash amount, which we addressed in our brief, was also subsumed within a $100,000 expense limitation. Then we also have issues on our cross-appeal concerning legal fees and the sanctions that were awarded by the trial court when Mr. Keane sought to arbitrate disputes that were resolved at trial, which is addressed in our brief. I think my time is limited.
You'll each have 2 minutes to respond, so you'll have a couple of minutes to raise that afterwards, okay?
Thank you, Your Honor.
Thank you, Mr. Rosenstock. Mr. Keane?
Judge Kaplan? Let me just really quickly go over the math involved because Mr. Gladstein is not missing $400,000. Exhibit I at page 1718 shows the math. $473,000 came in of old money against $473,000 of old obligations were paid against $321,000 of money, $152,000. Clear as day at page 1718, Exhibit I. So this finding $400,000 stuff is really just to cloud you.
How do you respond to counsel about the $250,000 offset sought by plaintiff?
Judge Singh, I'm sorry, I didn't make myself clear. That's what I'm telling you. The offset of $250,000 is based upon a failure, deliberate or otherwise, to understand the math that was clearly set out by Mark Rossman at the trial. We had to keep track of the old expenses and the new expenses, and we had to keep track of the old money and the new money. And the formula that Mark showed was that it was $150,000, which goes to why did I sign a note for $180,000? Because Harvey told me that that's what was owed. The record clearly shows that the only amount owed was $150,000. That's, again, right on Exhibit I. $150,000 was owed. He added $30,000 for certain things like Janie's artwork and tax on a car that didn't belong there. And he didn't tell me that when I signed the note. He said, Margie says it's $180,000.
I mean, again, I just ask a general question that I think we've all asked is, I mean, this is an appeal after a trial before a judge who heard all this testimony, all this information about the offsets, evaluated the witnesses, evaluated the testimony, wrote the decision. Why should we set that aside when she had the opportunity to observe all the witnesses and make her findings after the trial?
Judge Kapnick, when the record clearly shows, for example, that I did pay $23,000 in FICA, and the judge says, I don't know that they paid that because it's on the payroll. Mr. Rossman's testimony was that the employee pays their part of FICA and the employer pays their part. So
But
I'm
isn't
not
that
getting my FICA
Isn't
back.
that the role of a trial court?
I'm sorry?
Isn't the role of the trial court to listen to the evidence and make factual determinations based on credibility, based on the strength of the documents? And isn't that what occurred here?
There's no question of fact but that I paid that money. There's no one says I didn't pay that money. It's right there. It's right in the record. It's clear.
Okay, thank you very much, Mr. Keane. Mr. Rosenstock, you have 2 more minutes.
One, I should note that Mr. Keane's brief is almost devoid of any record references whatsoever. So I don't really know how he can say it's in the record and then to come here today and say it's in the record when there's no support for it. If you look at Exhibit JJ, which we cite in our brief and give the record reference at page 1776 thereafter, it states, Thomas Keane responsibility paid by Harvey Gladstein funds. And at the end it says $473,000. I don't care what type of double talk Mr. Keane wants to indulge in. The fact is that his own bookkeeper record shows that $473,000 of Mr. Gladstein's funds were paid into Mr. Keane's law firm account and used to pay Keane's law firm expenses. That's it. There's no
Counsel, I
question
know
about
that
it.
you're also looking for additional fees, not only fees with respect to enforcing the note, but also defending with respect
Yes,
to
we,
settles.
thank
My
you.
question,
We'll
if I
address
could
that, but I
just
think
finish. My
this-
question to you is, in seeking the additional fees, the invoices that you submitted, did they clearly set forth the nature of the work and then the particular claims that you were working on? So I thought that was an issue that perhaps you didn't really set forth the nature and the particular claims. Can you address that?
Yes, well, we annexed and submitted to the court our detailed billing records, which showed, the services rendered on a day-by-day basis by each attorney, by each month, and just for this matter. And it specified the exact work that was done. And we did address it, I think, in our reply brief in more detail, because we were running out of the room, quite frankly, when we did our first brief, some of these issues. And Justice Schechter did, break it down, but her main rationale for denying our fees was not that our fees were not described adequately, or not that there was not detail, but she came to what we believe is the erroneous conclusion that we were not allowed to recover fees in responding to Mr. Keane's set-off and other affirmative defenses. I think that is contrary to what this court has held repeatedly, and I think the detail of our bills are not really in dispute. It's just a question of the theory whether or not that type of fee should be recoverable, and I believe that they should be.
Okay, well, I thank you both for the arguments. We will look over the papers further, and thank you for coming in.
Thank you very much.
Have a nice day. The next case for argument will be Joseph Pavich versus Raymond Pavich. May step up.
Good afternoon, Your Honors. May it please the Court. My name is Aaron Schlossberg of the Law Office of Aaron Schlossberg for the appellant. Your Honors, the lower court improperly dismissed this complaint against the defendant, World Cinema, because the complaint adequately pleads a cause of action for breach of contract. In fact, it pleads a cause of action adequately for many contracts. World Cinema even admitted that there were multiple contracts. There's a very lenient standard. Obviously, Your Honors are aware of this on a motion to dismiss. It seems to have been completely disregarded. The motion seems to have been decided rather on
Counsel, what have you alleged that pleads the elements of a breach of contract?
Your Honor, we allege the 4 elements: that there was an enforceable contract in place, that more than one, in fact, that my client performed under the contract services, that the defendant failed to perform, namely failed to pay under certain contracts, and that as an approximate result of that failure, my client was damaged. And that's all we need to plead. The case law couldn't be clearer. And it seems like the judge in the lower court decided more on a summary judgment, went ahead and said, well, talked about amounts, and the contract wasn't, decided more on whether the case could be won or not. And that's not the standard on a motion to dismiss. There can be no reasonable question that we alleged the elements necessary to succeed on a motion to dismiss.
Now, in this particular case, I know that the plaintiffs had a long-standing business relationship with the defendant, what was it called? WCR?
World Cinema,
World
yeah.
Cinema. So they had a long-standing, and they would do a lot of projects. Was there, and you allege that each of these jobs entailed its own contract with WCI. Was there, in fact, a separate contract for each one of these jobs?
So yes, there wasn't an extremely formal contract, 30 pages long.
I think that might have been the problem here.
I think you're right, Your Honor, but as you know, contracts can be invoices and emails. There's a course of conduct. We had more than just a course of conduct. We have more than an implied contract, but at a minimum, there was an implied contract. I think there were many hundreds of contracts over decades between these parties, and they're coming in saying we didn't have a contract.
Now, they were your only client for?
It was the biggest client by far for many years. I think there may have been some other clients, but this was my client's business. I mean, that's why this case is so important to him. I mean, it's up and gone up in smoke. But this was his primary source of income was through this company. It's a fairly medium to large size company. It does work all over the country. So,
Here, counsel, you're alleging that the defendants breached the contracts either by failing to pay for the work or taking the work away from your client.
That's exactly right, Your Honor. There are multiple claims. I wanted to focus specifically on the breach of contract claim, which is mainly because it's very simple. They didn't pay on a number of contracts. We do also have a breach of good faith and fair dealing claim. Exactly.
I want to ask you about that. Isn't that claim duplicative of your breach of contract claim?
It's not, Your Honor. And the reason for that is because aside from the facts and the damages stemming from my client providing services and not getting paid, there was an understanding, it is alleged sufficiently, that there was an understanding between my client and Defendant World Cinema as to the working relationship. And when my client brought in his son, Ray Pavich, who's another defendant in this case, who was not dismissed, they had an understanding too. Ray Pavich had a checkered history and was having trouble, and my client, his father, took him in and said, you can work for me, but you can't work, don't take my business from World Cinema. And we actually it's not on the record, but he's conceded that there was some sort of understanding there. In any event, the allegation is that World Cinema was aware of that, Ray Pavich was aware of that, and that they worked together. And there are emails to support this, that they worked together and started and ultimately cut my client out and worked together. So those are separate facts alleging a bad faith violation that stemmed from the contractual.
That sounds like more of a tortious interference claim than breach of implied covenant of good faith and fair dealing.
We have I think I agree that they're similar, Your Honor. I believe we have tortious interference alleged in there. Since the contract was initially between World Cinema and my client, the tortious interference, I think we allege more against Ray, who came in and interfered with that contract. But the other claims against World Cinema is breach of good faith because they knew. They knew the arrangement. They knew my client was bringing in his son, and the arrangement was, okay, we'll get, and all of the work was assigned through my client's company, MATV. And then my client dispersed that work to Ray. And World Cinema knew this. So the allegations, and I think they're adequately pleaded, again, this is a motion to dismiss. It's just, did we state a claim? Not did we prove it or can we prove it? And there can't be any reasonable dispute that we alleged a contract claim and the breach of good faith claim as well. And you may hear something about specific provisions being identified, and I don't want to waste the court's time. It's briefed, but just very briefly, again, there's a very lenient standard on a motion to dismiss. There's no heightened particularity requirement in contracts, and we pointed as best we could to the provisions that were violated. And there's no question that we apprised the court and the parties of the nature of the claims. I mean, There can't be a reasonable claim otherwise. They know what's being alleged here, and that's all that has to have been done. And even the cases that my opponent cites as to, well, you need to be very specific in your contract claims, it says, as long as you address, you state what the terms, the general substance of the contract provisions that were alleged, as long as you provide, notice, as long as you apprise them of the claims, nobody can come in front of your honors and say that they didn't know what the claims were.
Okay, thank you very much. You'll have 2 minutes to
Thank you, Your
respond to the respondent.
Good afternoon.
Good
May
afternoon.
it please the court, my name is Ryan Sestak, and I represent WCI, the respondent. There are many things that I'd like to address. The first being that of the standard. The plaintiff has the burden to adequately plead a claim. Part of establishing or part of adequately claiming a breach of contract is to identify a contract that was breached and a provision of that contract. A plaintiff can't come in and say there are hundreds of contracts between two parties and not identify which of those 100 was breached and which provision of which contract was breached.
Since I have the complaint in front of me, I thought that there were at least 9 specific contracts that they said that they had a contract with you for 9 specific jobs that ultimately they did not get paid on because they were stolen by the son, Raymond, and his company. So I asked that question, or was there a contract for every job? And he said, yes, in this particular case, it didn't have to be formal contract, but you had a very long-standing business relationship, and each job, you had emails back and forth and work orders and whatever, and that constituted the contract. It at least sets forth a claim.
Well, Your Honor, you're referring to paragraph 38 of the complaint that lists 9 hotels.
I am.
First of all, a hotel is not a job, but
Well, that's where you did the jobs with.
there's a
hotels.
fundamental defect, and paragraph 38 itself says that these jobs were stolen, whatever that might mean. Apparently, the co-defendant, Joseph Pavich's son, Ray, who had his own company, Superior Satellite, stole those jobs. That's a factual allegation, and there are plenty of allegations throughout the complaint about the plaintiffs being excluded. So if the jobs, whatever those jobs may be, and they're not specified in the complaint, done at any of those 9 hotels, if those jobs...
Isn't that the purpose of a bill of particulars? To amplify the pleadings? I mean, isn't that what the issue here is? That you ask for a bill of particulars and say, specify the 9 jobs. What did the work entail? How much were you supposed to be paid? How much weren't you paid? Et cetera, et cetera. Isn't that how we do this?
No, Your Honor. You get to the bill of particulars once you adequately plead a claim. And just to finish my thought, and I'll address that, if the work was stolen by Ray and Superior Satellite, then the plaintiffs didn't do the work. So they can't say that they weren't paid for the work that they didn't do. If the plaintiffs say that Ray didn't steal the work and they did it, then it contradicts the allegations in their complaint.
Well, they're entitled on a motion to dismiss to an inference that every favorable inference that there can be, and to an assumption that their allegations are truthful. That's what the standard is.
Right. The allegation is that the plaintiffs were excluded, that the other co-defendants conspired, and that Ray Pavich stole the jobs. If Ray Pavich and his company did the work, then Joe Pavich and his company can't complain that they didn't get paid for work
Well, they're complaining they didn't get paid because they didn't have the opportunity to do the work so that they would be paid. I mean, it seems kind of obvious.
The plaintiffs aren't entitled to get work from WCI. WCI has no obligation to provide any job.
Who do you represent?
WCI. This is an issue.
But counsel, it sounds to me that you're making a motion for summary judgment. I mean, you may prevail on motion for summary judgment, but we're at the pleading stage of this case. Are you on notice of their pleading?
No, absolutely. What jobs?
What jobs?
Where? How much was owed?
Well, the thing is, what you did was install things at residences and mostly hotels. That's what you did. And he's saying we had jobs with these various hotels. We had plans to do the work there. And somehow we didn't get to do the work because you allowed the other person to do the work. I mean, I understand that the son was working with his company at the beginning, and then he started his own company, and it sort of morphed into his company.
Right, Your
trying to
Honor,
cut him
but
out. Look, he's a defendant in this case, too, but he's also saying that you were part of this, and he's making claims that those jobs are jobs he should have had, that he didn't have. He had a contract with them, and you breached it by letting the other person do the work and not letting him do the work.
Your
That's
Honor.
at least his claim.
Your Honor, I think the court could ask opposing counsel which contract, what date, what work. You can't list hotel names and say that there's contract. Again, WCI did not have to give the plaintiffs any work. There was no exclusivity provision in any contract between them. WCI could have hired Ray.
That's a defense that you'll raise in your answer.
No, Your Honor. The notice requirement for breach of contract is identify the contract and identify the provision.
I know about all those elements.
We don't have notice. If I were to conduct a deposition of the plaintiff, my first task would be, what contracts are you alleging were breached?
But you're not at that stage yet, sir.
Excuse me?
You are not at that stage.
No, I understand. I'm saying
as
we
one
can't
of my
go there.
colleagues said, many of the things that you're using as an example belong in the bill of particulars, not in the complaint.
No, Your Honor. The court, if you can't answer this question, what contract or what invoice, and I haven't even gotten to the invoices, I know they don't cure the defects in the complaint, but what contract, what provision was breached? You can't honestly answer that question because it's not in the complaint. A hotel is not a contract. If there was work done at a particular hotel and that involved the issuing of an invoice, then that itself could be the contract, but we don't have that here. What we have here is a vague allegation about hotels without any sufficient particularity. The standard under CPLR 3013 to provide notice is sufficient particularity. You can't answer that question of which provision of which contract was breached.
Okay.
And just to conclude.
All right, just finish up then.
Again, the actual grievance here is that WCI didn't give work to the plaintiffs. WCI has no obligation to give the plaintiffs work. WCI is not prohibited from giving the co-defendants work. And if you take their allegations as alleged in the complaint as true, which we must at this stage, then the plaintiffs themselves said that they didn't get the work. It went to the co-defendants. So how could the plaintiffs claim that they weren't paid for work they didn't get?
It sounds like you're telling us what your answer is going to say.
No, Your Honor. This is just a notice standard under CPLR 3013. It's black letter law that the failure to provide.
Okay, thank you very much. We'll allow the appellant 2 minutes if you'd like to respond to anything responded to. Thank you.
Thank you very much, Your Honors. I don't have much to add. I mean, as Your Honor mentioned, the projects are right here in paragraph 38. I think it's somewhat specious to suggest that we have no idea what they're talking about. This is the way contracts were referred to by these parties, and I think the vast majority of contractors out there for decades, they call it by the project name. That's the title of the emails, and I put it in my reply brief, so hopefully you have a chance to look at it. It says they even use their own identifying number and the name of the property, just like we do. That's how that's how his client identifies the project. So of course they know what contracts these are. Of course. What else could they possibly?
You did one kind of work, and you did it for a hotel, mostly for hotels.
That's
right?
it. This is all they
But
install.
entertainment systems or
Entertainment and TV systems in hotels. That's what his company does. That's what my client's company, my client's companies do. That's what they do. They had one project at each of these premises. This is how they would be assigned. His principal would call up mine. Hey, go to the Moxie Hotel. We need, something set up there. I mean, that's how they refer to the projects. These are contracts. They're one and the same, and they have their own identifying numbers on the emails. So of course contracts were alleged. They didn't pay, and they are treating this like a summary judgment motion. And I don't want to spend any more time than necessary. I appreciate the time, Your Honors. Thank you.
Okay. Counselors, thank you very much. We'll look at it further. Okay. You don't have a cross appeal, so you don't get any more time. That's only if you have a cross appeal.
You left your bag there.
Okay, thank you very much. The next case for oral argument is Slemish, I'm sorry, I'm not sure how to pronounce the name, against Robert Morgenthau. That name I know how to pronounce. Slemish, not Flemish. I'm not sure. Okay, good afternoon. Counsel, I'm sorry if I messed up the name of your client.
I'm embarrassed to tell you that I can't tell you whether you did or not, Your Honor. I don't know.
all right.
I've been saying Slemish, but now that you mention it, I'm not even sure I'm right.
Okay, I'll go with Slemish. Nice to see you, Mr. Smith, and you may proceed.
Okay. I want to begin, if I can, by putting in perspective what happened. The district attorney brought a forfeiture proceeding against Beacon Hill. It knew from the outset, and it told the court when it seized the funds, that Beacon Hill was holding the money as agents for its clients, and that couldn't be much clearer in the record. The district attorney has never to this day claimed that Beacon Hill was the owner of the funds. You'll find in the record at page 69.
Are your clients the owners of the funds here? I mean, have they established that?
I think they did, Your Honor, yes.
How did they establish that?
They established it by their own testimony, by an affidavit of an expert who says that in this business, under Paraguayan law, the exchange house is the owner of the funds and not the customers. I would add, Your Honor, that I don't think the true owner theory works. That is, that even if they were holding it for their clients, that doesn't mean a third party can come along and take it away. In an action for money hadn't received, the issue is who has the superior claim to the funds. There's no doubt that my clients have a superior claim to Beacon Hill, but I think there's also no doubt that we're the owners of the funds. Certainly Beacon Hill was not. Ms. Gilmain says in the record at page 69, addressing the court, I've never said specifically whether Beacon Hill was the owner of the money, and she said that in 2016, 12 years after the district attorney took the money, and the district attorney has no entitlement to that money except as the successor to Beacon Hill. And if you go to page 1609, which you'll see an email from an assistant district attorney written in June of 2003 before the forfeiture to Beacon Hill's lawyer. It says, you told me that the money belongs to Beacon Hill's clients. Now, I think originally the district attorney may not have thought it was a problem that Beacon Hill didn't own the money, because they probably then thought in good faith that all these clients are all bad guys, they're drug dealers, they're money launderers, they're never going to show up and claim the money. But they were wrong, at least as to many of the clients. It turned out that there were legitimate businesses like my clients, and we go into some detail about our business. They hired a lawyer. He wrote to the DA and said, this is my client's money, and they're going to claim it.
Well, let me ask you something. You bring up an interesting point. Your clients hired a lawyer to monitor the forfeiture procedure way back when, and they did. They never said anything or made any motion to intervene or say anything about their funds, and they waited they waited quite a while to bring this particular action. I know there was another action in between. And there was questions raised about the validity of or the integrity of the work on the part of your clients. So how have you answered all of those issues?
Well, it's certainly true that my clients did not intervene in the forfeiture proceeding. And if the statutory remedy were exclusive, then I would have to say to you, and I would have no hesitation in saying to you, that what happened here, the sleight of hand that happened here, where the district attorney, knowing he had no right to the funds and knowing that the true owners were standing there, decided to take advantage of what he thought was a loophole and say, okay, I've just settled the case, it's over, I don't care whether it's your money, I keep it. I think that's terribly unfair. I think it's fundamentally unfair. But there's a loophole in the loophole, if I may say it, and I think the district attorney missed it.
Well, isn't there shall I call it a preliminary issue here, of the fact that your clients never filed a notice of claim as required by County Law 52?
Well, it's not required by County Law 52, Your Honor, because it's not an action against a county, nor is it required by General Municipal Law 50K, because that's a defense and indemnification statute. There is no notice of claim requirement for a money had and received claim. It's a contractual claim. There are a lot of cases on that. If I could finish my answer to the presiding justice, I was saying there's a loophole in the loophole. That is Section 1311.5, it says no person, I'm sorry, it's not 1311.5, it's the money hadn't received claim, 1352. The remedies provided in this article are not intended to substitute for or limit or supersede the lawful authority of any public officer or agency or other person to enforce any other right or remedy provided for by law. It's indisputed, indeed, it's the law of this case. This court held in 2009 that we are entitled to, regardless of whether we should have intervened or shouldn't have intervened in the original forfeiture proceeding, it's not exclusive. We are entitled to assert a money hadn't received claim. The question here is, in 2009 you held that we had a prima facie case, but that there were issues of fact raised by the district attorney's defenses. The issue here is whether, after a lot of years of discovery, there really are any defenses. I think it's clear that there are not. I don't have time to go into a great deal of detail, but certainly there's not a notice of claim defense, because this notice of claim doesn't apply to money hadn't received. Contrary to what my adversary says, it was indeed preserved. It was preserved in so many words, right in the brief, which I quote. It says, the notice of claim defense does not apply here. This is not a tort case, and that's at pages 511.
I'm sorry, can we go back to County Law 52? You say that you're not suing the county, but how have you named the district attorney in this case, in this lawsuit? Haven't you named the district attorney as district attorney of New York County? And isn't that sufficient?
Yes, we have.
So aren't you, in effect...
has demonstrated very persuasively that despite that he is the district attorney of New York County, that's what he's called, and the voters of the county elect him, but the city pays his salary, and it is part of Ms. Gilmain's defense here that he's a city employee. And the funds here are city funds, not county funds. So I think it's quite clear that I don't think her county law defense really is her major one. She's really relying on the general municipal law 50K, which she says doesn't require, isn't limited to tort claims, even though 50K is really just an indemnification statute, and it incorporates by reference 50E and 50I, which are limited to tort claims. So I really think it's quite clear that we do have a tort claim limitation in this case. The county law just doesn't apply. By the way, I don't think really although there is a case that says so, I have some doubt that even the county law was intended to say in a money hadn't received claim, you've got to give notice of claim. It doesn't really make sense. If it's a tort, obviously you want to give the defendant an opportunity to find out whether that person really did slip in the pothole. Well, how hard is it to figure out whether you got somebody else's money or not if it's sitting in your bank account?
Didn't the Court of Appeals in the case of Boyle v. Kelly give a very broad interpretation to that section?
I'm sorry, what's the name of the case?
Didn't the Court of Appeals in the case of Boyle versus Kelly give a very broad interpretation of the applicability of that section?
Are you talking about the county law?
Yes.
I don't know the specific answer to your question, Your Honor. I don't think my adversary has cited a case which would indicate that the district attorney can count as a county, even though it does say...
Not counting it as a county, but applying to monies wrongfully retained. You were just discussing that it only applies to tort actions.
Oh, I'm sorry.
And I think in that case, the Court of Appeals interpreted the section as broadly applying to monies wrongfully retained.
Yes. Oh, yes. It certainly is. It's a basic proposition that it is broadly applied to money wrongfully detained. That's my case. Yes.
So and in that case, they said that a notice of claim is required.
I'm not remembering the case specifically, I do not believe that there is a case that says notice of claim is required in a money hadn't received case.
Okay. Thank you very much. We'll hear from the respondent, and of course, you'll have 2 minutes to rebut her argument. Thank you.
Okay.
You may proceed.
May it please the court, my name is Madeline Gilmain. I represent the defendant respondent, Robert Morgenthau, in this case. I'd actually like to initially respond to the last question asked of plaintiff's counsel. County Law 52 And I do cite Boyle v. Kelly in my brief, and that was a case in which the police commissioner, I think of Suffolk County, had been sued. And County Law 52 was brought in stating that notice of claim was necessary. And I would point out that even though that section does then refer to sections, I think it's 50E and 50I, which are tort actions, but in the express language of 52, it states in the first sentence that it applies not only to a number of claims that are described almost like tort actions, but also any other claim for damages arising at law or in equity. So although Boyle versus Kelly was not expressly a money had and received case, I think it's clear from County Law 52 that it's intended to apply to much more than tort cases.
But I think that the first issue is this an action against the county for damages? So the district attorney, is he a city employee? Is he a county employee?
Well, I think
the funds, are they county funds, city funds?
Well, it's the funds were seized by, the district attorney Morgenthau is both a county officer. He's also a city employee. It depends on the context and the situation. When he stands up in Supreme Court criminal term on behalf of the people, he represents the people of the state of New York. So, I mean, the funds in this case that were seized as for forfeiture funds, and which were forfeited by Beacon Hill. And I'd like to focus on that. I mean, where the funds to pay this money would come from now is frankly not clear. It's now 16 years later, so it's a little hard to categorize what that money becomes after it was forfeited.
That money has long been dispersed.
It's gone. And part of it went to, this was all distributed under CPLR 1349. A portion of it was kept by the office, and by law, a significant amount of it was paid over to Oasis under 1349. Your Honors, this is the third time this case has been before this court on appeal. And I don't know if Judge Mazzarelli, if you remember, because you were actually on the panel for the original case in 2008.
Yes, my memory goes back at least that far.
And you may perhaps remember that what they did in that instance was they were asking this court to convert their original untimely 1327 action to a 1311 action. And one of the elements of that was that they had to assert they had no notice of the forfeiture action. That's one of the elements under 1311 that they had to demonstrate. They claimed, and this court partly gave them permission to go back and convert their claim to a 1311 because they argued that they had had no notice of the forfeiture action.
And that could never have been true because, I mean, they had an attorney that was observing the forfeiture action. Am I correct?
Yes. We didn't know that until 2013.
Oh, okay.
They actually kept that information hidden. And it was something that came out during discovery proceedings, that they had consulted with these lawyers and all those communications. We did not actually get those communications until we did a motion to compel those documents in 2013. So this court was not aware of that when they gave them permission to go ahead with the 1311 action on the first appeal in 2008. And in 2009, they were here on their first summary judgment motion for money had and received. And the court sent it back for discovery proceedings because my office had raised substantial facts that were at issue that needed to be addressed on discovery. And the court even pointed out that the plaintiffs were in sole possession of all of the facts, of all of the evidence. They then waited until 2012 to tell us that they had actually destroyed the business records we had been seeking on discovery since the beginning of this case. And let me just say, despite the references to the record where there were early instances, early discussions at the beginning of the forfeiture case about whose money is this, what legal authority did Beacon Hill have to forfeit this money, it is true, I don't in my papers argue that Beacon Hill was the owner of the money, but I have always asserted that they had a superior interest in the money and they had the legal authority to forfeit the money under the terms of the master agreement they had with their clients. The forfeiture stipulation was so ordered by the judge, Judge Shulman, in the original asset forfeiture proceeding. He was fully aware of all the same facts that we had at that instance, and he signed off on it. And in addition to finding out during discovery proceedings that they had actual notice of the forfeiture action, we found out a number of other things as well. For example, there had been an argument in the first summary judgment proceedings They claimed that the forfeiture stipulation didn't actually intend to forfeit all of the money. They claimed it was only an interest, and that interest was much smaller than the entire contents of bank accounts. They have abandoned that argument since then. There's no question now that Beacon Hill intended to forfeit that money, and that everybody at the time of that forfeiture was in agreement that that money was subject to forfeiture. Even the plaintiff's own attorney, William Brodsky, who was the lawyer they were consulting with at the time, admitted that he believed those funds were subject to forfeiture. And if you look at his communications to the plaintiffs while this whole case was proceeding, he informed them that if Beacon Hill were convicted of the criminal activity, that those funds were going to be forfeited. And they still did nothing. They waited not only, a lot of their claim is on whether or not they were blindsided by the forfeiture stipulation, as opposed to getting some kind of notice that there was a judgment and then having to go proceed. But once they were notified of the forfeiture stipulation, they waited 6 months to file a 1327 action, made no mention of the forfeiture stipulation, made no argument about how they were somehow prevented from making a timely application. Instead, they pursued this 1311 remedy without informing the court that they had consulted with these lawyers all this time.
So is it your contention that they shouldn't have been allowed to move under, I think it's 1311(7), right? Is it your position that they should not have been allowed?
Yes,
to
because
move under that provision because they were on notice through retained counsel?
Yes, and in fact, that was one of the reasons that their current 1311 claim that they've been spending all this time on was denied by Judge Shulman. As to the ownership issue, Judge Shulman found that they had not sufficiently demonstrated their ownership of the funds. Again, he presided over this case for many, many years. He was there for all the discovery proceedings. He spent a year with the documents on this summary judgment motion and had so much time and so much thought. We had so many conferences about all of these issues. And with all of this information in front of him, he believed that they had not sufficiently demonstrated their ownership of the funds. That eliminates their 1311 claim. It eliminates the money hadn't received claim. And without that, they really don't have a basis to proceed in this case.
Just have a few seconds, so anything you want to wrap up?
Again, they're challenging also the constitutionality of Article 13A. And I would argue that their reasons for having been unable to succeed in this case has nothing to do with the way the language is, of the way the statute is structured. It was decisions they made. It was their failure to come forward. It was their failure to provide the facts. And it was a failure on their own part to provide sufficient evidence for their claims, not the constitutionality of the statute. Thank you.
Thank you very much.
Just a couple of things. Let me start with Ms. Gilmain's statement that whether or not the Beacon Hill owned the money, it had an interest in the money. First of all, I do not think it is logical to say that because they had an interest in the money, they're entitled to forfeit their own interest and everybody else's. It doesn't make sense. My clients unquestionably had an interest in money. Anyway, the argument that they had an interest in the money is the one that she incorporated by reference from her brief below. It's not actually articulated in her brief. And the argument is that because the master agency agreement between my clients and Beacon Hill said that if there were litigation, they could apply the funds to the attorney's fees of that litigation, well, then we're going to apply it to settling the litigation. We're going to take all of it and use it to settle the case. That's their interest in the money. It's an absolutely outrageous argument. It doesn't make any sense. I will touch briefly on a couple of other things that my adversary said. She keeps saying we destroyed documents. There's no real spoliation case here. The only evidence is...
her argument that we should not have allowed this petition under 1311 because, in fact, your clients were on notice of the forfeiture proceedings based through retained counsel.
Yes, I think that is her argument, and I'm not directing my arguments this morning, particularly the 1311 claim. I'm saying I've got a common law money hadn't received claim. And it's not barred by the county law, it's not barred by the municipal law.
If that's correct, then are you still making a constitutional argument, or you're not?
Well, no, the
I mean, you can't have it both ways, right?
It's an alternative, Judge. You do not need the constitutional argument if we prevail on money hadn't received. That's quite right.
Agreed, agreed.
If I fail on money hadn't received, yes, I'm making a constitutional argument.
Okay,
I'm
but
saying
then don't you have to still address the assertion that your clients retained counsel and were on notice of the forfeiture proceeding?
I understand the problem, Judge. My answer is that counsel acted reasonably, that the DA knew exactly what was going on, that the DA knew from the start that he had no right to this money. There's never been a coherent claim that this was Beacon Hill's money, and that it is fundamentally unfair for the district attorney to do what he did. But I do emphasize that you don't reach that claim if I prevail on the money hadn't received claim, and I think I should.
Okay, thank you both very much, and we will take some further looks at these papers. Have a wonderful afternoon. Thank you. The next case to get ready for oral argument will be Trinidad versus Turner Construction. Just get, is there a respondent in this case?
They're not here today.
They're not here today?
They chose not to do argument. So we're happy to submit, but there's just a case that was recently decided that we want to call the court's attention to.
But I gave time to both sides, right? It's just that they decided not to come in?
That's correct.
Oh, well, that's odd. In this new found world, it's not usual. Okay, so then I'm not going to give you 7 and 2. How about if I give you 5 minutes, and if you need them, you'll take them, and if not, that's fine. Okay? Thank you. So you're the appellant?
Yes.
Okay. All right, you may proceed.
Okay. May it please the court, Alan Zachary representing the appellant. And we're happy to just submit and rely on our briefs. But we just wanted to call the court's attention to a case that was decided by this court last week that has similar facts and we think is applicable. The case is called Kaufman v. Capital One Bank. It's 2020 NY Slip Op 06394.
What date was it decided?
On November 10th.
Thank you.
I believe you were on the panel.
I was on the panel. Okay, so tell us what you want about that case.
The case held that Industrial Code 23-1.7E1 applies not only when a hazard directly causes a worker to trip and slip, but also when, in circumstances like this case, where an object is being pushed by the plaintiff, becomes stuck on an obstruction, causing it to tip over and to injure plaintiff.
But there are a lot of cases that stand for that proposition, aren't there?
There are a line of cases that stand for that proposition, yes, Your Honor.
And was this also the one where you tried to, you wanted to amend your bill of particulars and the judge denied your right to do that? Is that this case?
Yes, Your Honor. And we believe there's no prejudice to amendment, and in the labor law context especially, even at the summary judgment stage, leave to amend is frequently granted to add different industrial code provisions that are applicable, and that's what we think should have been done here.
How about the 200 claim, sir?
200 claim.
Is this a defective condition theory, or is this means or methods?
We believe, at least in part, it is dangerous condition and should be treated as such, because it was a condition that existed before plaintiffs arrived at the site that day, and we cite case law that shows similar circumstances that supports that stand.
Now, there was some testimony with respect to inspections. Is that sufficient to make out a prima facie case for the defendants on this issue?
The testimony wasn't specific. It did not establish when it was last inspected prior to plaintiff's accident. It was from somebody who just was giving a general account of the inspection policies, which the case law says that's not sufficient to establish constructive notice.
Does anyone on the bench have any further questions? The other side isn't here. Oh, no.
Okay.
Okay, well, thank you for coming in and
right,
not
thank you very
taking up too much of our time, and thank you for pointing out that case to us.
All right, thank you.
Okay, the next case to be argued is Dana Jones versus New York Presbyterian Hospital. Good afternoon, counsel.
Good afternoon.
You may proceed.
Judge. Thank you. Everybody hear me? Okay. May it please the court, my name is Jeffrey Levine, and I represent Dana Jones, both at this court and in the lower court. I must confess that there are several issues that we need to review today, and I don't know that I'm going to get to all of them, so I just first want to give you an outline, and then I'm going to get into the arguments subject to whatever questions you have.
Well, remember, we have had the briefs and the record, so we are familiar with
I understand, Judge.
the facts.
The primary arguments that I have deal with the summary judgment motion, but there are some discovery matters, regardless of how you rule and whether or not you reverse the lower court. That'll be important because this was a 241-6, so we have comparative negligence that could theoretically play a role, and we'll be going forward with discovery and a trial potentially. So just quickly, we made a motion to, amongst the other relief requested, to strike the answer of the defendants because of the games that were being played, frankly, with discovery, and namely on the March 5th order of Judge Suarez. The judge completely overlooked our request to strike because of discovery abuses. The judge also overlooked the request for a perjury hearing from the non-party Maloney, didn't address that at all in his decision. And regarding the contempt of the non-party Maloney, the court on its own motion said that it was procedurally defective because of 756, that we didn't have the warning language on the face.
Oh, was that wrong?
That is incorrect, Judge, because under matter of Rappaport, which is a Court of Appeals case, it says if you then defend the motion on the merits, then that's waived. And that's precisely what the defendant did. I should also point out, importantly, that Cullen and Dyckman, which represents a defendant, and also noted in open court multiple times before Judge Suarez that they also represented the non-party. The non-party has never submitted anything to the court, either opposition or discovery. They've defaulted, which is why we asked for contempt, because obviously we can't strike the answer of a non-party.
Well, counsel, let's go back to that March 5th, 2019 order.
Yes.
Because that issue was resolved. It indicated that no surveillance videos existed. It was so ordered. And further, the plaintiffs had indicated that it would not produce any video of any accident or accident location at the truck. That was also resolved. You consented.
Excuse me, Judge Mazzarelli, you're right. That is the language actually.
My name is Justice Kennedy. My name is Justice Kennedy.
I'm sorry.
That's okay, it's confusing.
Judge Kennedy, I am so complimented.
I apologize. I don't see
take
who's,
it.
because
I'll
of the
take it.
masks, I don't see who's reading to me. I
Oh,
apologize.
I'll take it, though.
You're right. That language actually appeared not in the order, but in the compliance conference. And
No videos existed.
it didn't say they never existed. They refused to do Jackson affidavits, and that was about the best we could do after more than a year of getting orders and demands that we want the surveillance. And that's actually not the issue regarding contempt. That's just regarding the defendant.
Now I am going to speak. Now I am going to speak, Judge Mazzarelli, okay?
I'm sorry.
That's all right. But I think fundamentally, I would like to hear what your arguments are regarding whether or not your client is entitled to summary disposition of the 241 sub 6 claim. I think,
Sure.
That whole thing, I mean,
Sure. Let me
contempt
get.
and subpoenas don't make any difference if we don't have any claim.
Well, okay. This was our motion for summary judgment, and you're right. So let me get to that. First thing before I even start, I'd like to draw your attention to the record, page 50, which is part of Dana Jones's first affidavit in the summary judgment motion, and there's a color photograph that I'm sure you've all seen. That speaks 1,000 words, I think. It's a narrow passageway. This is in relation to a construction of a hospital, New York Presbyterian Hospital across the street from the old New York Presbyterian Hospital. It's a high-rise. It's enclosing a security perimeter abutting the newly constructed high-rise. So there's a structure abutting a building. Under 241.6, of course, we have the case of Mosher from the Court of Appeals that says this is not only involving buildings, all areas, all areas. And I know this court under Quigley tries to restrict a little bit more than the common definition of what a passageway is.
Well, can we just go back? Because actually the denial was based on the fact that it was premature.
Right.
You have no depositions to even indicate with respect to whether or not the code, the industrial code, is even applicable here, or was the object an integral part of the work. There were no depositions here. There were issues. I mean, everything was denied with respect to summary judgment because premature.
I understand that, and the judge did rule that it was premature. However,
So you disagree, of course.
I do respectfully disagree. I argued, and this was the last time I was in this courthouse, Ercan versus McDonald's. It was similarly a pre-EBT motion for summary judgment under the labor law, and that was granted as long as we can make out our prima facie case, and the defendant makes out their burden once it shifts, that we are in the exclusive control of some information that would warrant the denial, then we lose. But if we make out the prima facie case...
Isn't there a claim, counsel, that your client, while he was walking in this alleged passageway, which was outside, but that does not preclude it, I agree with you, from being considered a passageway under the definition in the industrial code, that he fell over an object, and there was some question that the defendants raised about whether or not that item over which he fell was actually an integral part of the work, which might preclude it, and this would be something that maybe some discovery would help us with.
Sure, if they submitted it in an admissible and a non-conclusory way. It was one sentence in their affidavit by a non-party who said it's not integral. That's not sufficient to make out their burden. And I would even go one step further. I'm sorry, they said it was integral. Our position is that it's not, because it was a tripwire, that they circumvented the internal safety features of the Yodoc water-filled barricade by using an external feature as a tripwire. How could an external feature that circumvents a safety feature that's built in by the manufacturer and act as a tripwire ever be integral either to the plaintiff's work that he was doing that day, which was a cleaner, or to the construction of a hospital?
Okay, I need to stop because we still have a lot of arguments, but you will have 2 minutes to respond to the defendant response.
Thank you, Judge. Any way I can reclaim the prior case's excess time?
No. Sorry. Doesn't work like that.
Good afternoon, Your Honors.
Good afternoon.
May it please the Court. My name is Adam Del Vecchio. I represent New York and Presbyterian Hospital. I'm here with the law firm Cullen and Dyckman. I'm here to respectfully request that the Court affirm the lower court's denial of the plaintiff's summary judgment motion, affirm the denial of the motion for spoliation for sanctions, affirm the denial of the motion for contempt, and also search the record and find summary judgment in favor of New York Presbyterian Hospital. At a minimum, there's plenty of evidence, indication in the record that this is a premature application, given that there are many factual bases on which a finding could be made that the
Well, if
area...
it's premature, then how are we going to search the record and find for you? I mean,
Well-
it's either premature or it's not premature.
Your Honor, that's a great question. With respect to the outstanding issues, there's only so many of them that defendants need in order to establish their entitlement to a defense in this case, whereas plaintiff must establish there's no issue of fact as to any of them. Plaintiff has not set forth that case, but there is sufficient evidence on which this court can find that a flatbed truck cannot create a passageway when it's parked inside a loading bay. There is sufficient evidence.
I don't think I don't think he was saying the flatbed truck created, was the passageway. I mean, I looked at the pictures and there was a fence that was on top of a Jersey barrier, and on the other side, it was kind of a narrow area, and on the other side there was a flatbed truck, which forced the worker to go through a pretty narrow passageway. I think that's what he was saying. At least that's how I understood the pictures.
Your Honor, I just want to note also, just to draw particular attention to the fact that throughout the plaintiff's affidavit, he reiterates that the pictures don't necessarily describe all the conditions very vaguely, which is a perfect example of why discovery would be necessary for him to establish his burden. However, finding that a flatbed truck that's parked in a loading bay can comprise one portion of a passageway would be inconsistent with this court's precedent with respect to what can establish a passageway. It has to be something that connects parts of a building, lead from one place to another. This is just a truck that has pulled into a parking area, which will depart from the parking area. If any vehicle that pulls into some sort of parking area can give rise to a passageway case, then you could have a passageway case in any parking lot. Where there are not defined walkways that are established for that purpose. In addition, so being that is the evidence that's before the court, there's no question that flatbed truck is the basis for the passageway claim. So that evidence, while it does not meet plaintiff's burden of establishing there's a passageway, and if the court says that it might, would require more evidence to determine that. It is sufficient to show that it's not that it would not be a passageway. Now, moving on from the passageway, there's also an issue as to whether or not the actual weighted guardrail locks were integral to the work. This was a purposely laid device that, frankly, the plaintiff is not qualified to testify was laid incorrectly. The fact that it was not specifically delineated in the manufacturer's instructions, which plaintiff is not himself qualified to opine with respect to, that is not in and of itself establishing that they were not purposely laid, accomplishing an integral task to holding up that safety barrier fence, which is a precise safety device, which this court has held that has recognized that safety devices can be parts of things that are integral to the construction. It's not necessary that...
What about the wire he was talking about? How is that integral, and was that part of the item over which he claims he fell?
Absolutely. So it was a weight with a rope that was tied to a fence. And my adversary makes a point to argue that the device did not need that because it was part of a weighted barrier, but the fence was on top of the barrier. The rope is there to hold the fence in place. So this is a far cry from some sort of strewn material or debris. This, under no interpretation, can be deemed material that's a debris, discarded materials. It's something that's purposely laid for a specific purpose. The fact that it's not delineated in that way in the instruction manual that my adversary submitted with his papers does not mean it's not a purposely laid device that's integral to the work and part of a safety barrier that's certainly part of the construction project and far cry from scattered debris.
Do you want to take a few seconds to say anything about the spoliation or the contempt issues that he raised?
Thank you.
Very briefly.
Thank you, Your Honor. Just briefly, there is absolutely not one single element of spoliation that has been established here, most importantly of which that any such video recording of the incident ever existed. There's absolutely no basis whatsoever on which a spoliation finding can be made. let alone that dismissal is warranted. With respect to contempt, there are multiple bases for denial of that. First of all, there was no subpoena outstanding, as that was resolved by the court. So ordered court stipulation that we responded to. And if I could just briefly note that there was no indication in the record that our firm ever represented Mr. Maloney in connection with the subpoena that was served. And so we couldn't possibly waive 756 under the judicial law.
Okay, thank you very much. We'll hear from the appellant. You have 2 minutes to respond.
Thank you, Your Honors.
Thank you very much.
I just want to respond very briefly to what my adversary said. First, regarding spoliation and the subpoena, actually it is in the record. First time that Mr. Maloney was served was by the Sheriff of Westchester County. That was referenced in the record and in my arguments. And the second time he was served was by the attorney that appeared on behalf of him by Cullen and Dyckman. I served him personally, and he admitted service. He signed his name to the legal back, and I followed up with that in NICIF, saying, you identified in open court that you represented. You accepted this service after I asked you, do you accept service? Are you authorized? And he accepted it. These games that are being played are really outrageous, and it's something unprecedented to me that a law firm would come in and say, we represent the defendant and we represent the non-party multiple times in open court, and then never put it down in writing ever, and then put in footnotes. We don't represent, there's never been an appearance on his behalf. We don't know who the lawyer is. All this is not really good faith in the way officers of courts are supposed to interact with each other. It's pure games and dilatory tactics that I think are totally unacceptable and shouldn't be condoned. Regarding the other question about, the ropes, the guardrail locks, those of course are tools. And my client testified. Well, I think really the case hinges upon the affidavits submitted by my client and the photographs. I believe that they make out a prima facie case under 241, whether it's a passageway or whether it's a working area. Surely it's a working area. They're dismantling the hoist. Laborers, just before my client entered that area, took the pail and brought it into that area. And my client was advised by his immediate supervisor to go into the area, retrieve it, and bring it back so he could finish sweeping up the loading dock. The actual incident facts are pretty simple. I think what's more involved here in this court is whether or not the industrial code and the two codes that we've cited apply to 241-6. I would argue they both do. But even if you don't accept the passageway, which I know, Judge Kapnick, you said that you would tend to agree with, then you have the working area.
I said I'm not as sure that it's precluded. I'm not sure if I said I agreed with it, but okay.
I apologize.
That's okay.
I think it applies under the working area, and I think it also applies under passageway. And
Okay.
the misuse of everything there couldn't possibly be integral.
Okay, we will certainly take a look at this further, and I thank you both for coming in today.
Thank you, and
Okay, have a lovely
hope everybody
day.
stays well. You know, the school's just closed. While we're waiting, the breaking news is public school's just closed.
Well, I think we might.
I think it's the only thing that we can probably agree on. We wish everybody well here in the court and the court system.
You too. Okay, the next case for oral argument is matter of the Committee for Environmentally Sound Development against Amsterdam Avenue Redevelopment Associates and Board of Standards. Okay, ready?
Thank you.
Good
Justice
afternoon.
Kapnick, and may it please the court, Caitlin Halligan for Amsterdam Avenue Redevelopment Associates. First, thank you to the court for allowing us to appear in person today. We appreciate it. This appeal is about a permit issued by DOB and affirmed twice by BSA for a building that is virtually complete. Petitioners say the permit should be vacated and some huge chunk of a building in a densely populated neighborhood torn down because the zoning resolution unambiguously, they say, prohibits a zoning lot that includes partial tax lots.
Well, the actual zoning regulation is from quite a number of years ago, correct?
Yes, Your Honor. The provision at issue.
And that hasn't been that, that doesn't specifically, unambiguously say if it does or it doesn't include those partial tax lots.
That's exactly right, Your Honor. Those words appear nowhere in subsection 12D, and that is why Justice Perry erred in refusing to defer to the BSA's reading of the provision.
Now, part of the problem is that there was this Minkin memo from 1978, I guess, that interpreted it one way for a very long period of time.
Yes, that's right, Your Honor. So in 1978, Mr. Minkin, who was a senior DOB official, so it was contemporaneous with the enactment of 1210D in 1977, he issued a memo which said that zoning lots may include partial tax lots. DOB then followed that memo for the next 40 years and
So that's my question. Historically, how has DOB treated the lot at issue here with respect to the issue of use of tax lots and half-tax lots?
This is part of why DOB and even Mr. Zoltan, the lawyer at DOB who has come up with this alternative interpretation, said that DOB had no choice but to issue the permit here because the lots on this very block have been treated as zoning lots even though they include partial tax lots. So the practice of DOB, including on this lot, but also we identified 38 other lots around the city where there are partial tax lots. And so all of that would be thrown up in the air if this interpretation were to be applied retroactively, which is what petitioners are asking you to do here.
So the thing is, a bulletin came out a few days, it seems like, after Judge Perry's decision, which interpreted differently but wasn't retroactive?
So what DOB said in this final bulletin, and I should add that the bulletin has not been tested by BSA and certainly not in litigation. So whether this new interpretation would hold up is something that presumably would be resolved another day. But what DOB said in that bulletin expressly is that the new reading that it was adopting, and we do agree that DOB has discretion here because the statute is ambiguous, the new reading that it was adopted would only apply prospectively. And that's because of the disruptive effect that it would have to apply this new construction, which comes out of the blue, retroactively, not just to this lot, but to the 38 other lots around the city that also include partial tax lots. So that's why
Also, there have been many buildings constructed under this older interpretation, correct?
That's exactly right, Your Honor, and that's why.
I mean, Pan Am built, MetLife, excuse me. The MetLife building is one of these buildings, is it not?
It is, Your Honor, and that's why what Mr. Zoltan said, and this is at 866 of the record, even while advancing this different reading, he said, and I'm going to quote here because I think this really gets at the heart of it, he said, a reasonable person would have no reason to know that he or she could not rely on the Minkin memo because it had been in place and relied upon for 40 years. And so that's why we are asking the court to reverse, because Justice Perry disregarded the BSA's interpretation. He concluded on the second visit, the first time around he looked at it and he said, well, I'm not saying one way or the other, I'm going to send it back to BSA to take a second look. If it was unambiguous, you would think that it would be unambiguous on the first visit, but he sent it back, I think because it is in fact ambiguous, and BSA affirmed and explained why in a carefully detailed decision that's set forth at 428 to 30 of the record, went through all of these points.
Counselor, before you know, you've been spending your time on the interpretation issue, but it seems to me that there's a primary issue here, and that's mootness.
Absolutely,
If
Your
mootness
Honor.
applies, then we don't even necessarily get to interpretation. Why do you believe that the mootness doctrine applies in this case? And is there anything to suggest that the developer here acted in bad faith?
First of all, let me take that last question first. Absolutely not. And that's what DOB and BSA said. That's exactly why Mr. Zoltan said no reasonable person would have had any reason not to rely on the Minkin memo. There was a permit in place, affirmed twice. Justice Perry, on the first Article 78, refused petitioner's request to vacate it. So absolutely proceeding in good faith. Weeks certainly applies. The law is very clear that a petitioner who's challenging construction has to seek injunctive relief from this court. Let me tell you what happened time-wise. When the first Article 78 decision came down in March of 2019, petitioners then came back and again asked for a preliminary injunction. And they said that they would not be protected and would not be able to fully litigate this case if the court did not grant an injunction. The court declined. So then they filed a notice of appeal. Instead of coming to this court, as litigants do, I know, every day to ask for emergency relief, they did not do that. But not only that, they did not perfect their appeal. 9 separate dates went by, and they didn't perfect any of them. They even got 2 extensions and didn't perfect. And the only reason they give in their papers for not perfecting is that they decided that it did not make sense. Well, the law is clear from Weeks and from the Court of Appeals that if that's the litigation choice that a challenger makes, that then they are complicit in the building being complete, and there's no fact.
Back when they sought the injunction, how much of the building had been completed?
At the time that they sought the injunction, well, to step back, there was a stipulation that was in place, right, from May of 2018 until the date on which the Article 78 decision came down. Before that stipulation went into effect, the excavation was complete, the foundation had started, and $355 million had been spent. After the stipulation came down, to go to Your Honor's question, Justice Singh, 33 of the 55 floors of this building went up outside the window of the stipulation.
Is that, now are you saying is outside the window of the stipulation after the March 24th, 2019 decision by Judge Perry?
Absolutely,
Is that
because
it?
that's when the stipulations expired by their terms, and that's clear in the record at 282. The stipulations
I
are-
looked at it. I
I
just
see
wanna
my
make sure.
time is up. I am happy to answer any other questions.
You have 3 minutes for
Yes, I do,
rebuttal.
Your Honor.
Okay, so we'll hear from you some more
Thank you very much.
in a little while. Thank you. Okay, and Ms. Graves-Poller, on behalf of the city, correct?
Yes, Barbara Graves-Poller on behalf of the municipal appellants.
Good afternoon.
Good afternoon.
Okay, you may start whenever you'd like.
Sure. So the city agrees that this case has become moot, but we ask this court to vacate Justice Perry's order and judgment to avoid any negative consequences or confusion flowing from its many legal errors.
Let's assume, hypothetically, if we were to agree with you on the mootness issue, do we need to address the interpretation issue here?
If the court decides to dismiss on mootness, it doesn't need to go into detail on the interpretation issue, but the Justice Perry's
Does it
decision.
involve, for example, a novel or substantial issue that requires resolution or not?
To retain jurisdiction is Your Honor's question. This court case does not pose the kinds of concerns regarding novel or evanescent issues that came up in Pine Bush, so there's no reason to retain jurisdiction here. But I guess the point I was getting to was that Justice Perry's decision needs to be vacated because it directs the Department of Buildings to take specific action, and so that's why we were asking the court to take that approach, notwithstanding mootness. But if Your Honor doesn't have any other questions for the city on the mootness issue, I'd like to focus on the interpretive questions that the lower court really got wrong. And in many respects, the analysis begins and ends with this court's Parkway Village decision, because Justice Perry overlooked Parkway Village And it's not just that this court deferred to the BSA with respect to the specific provision that's at issue here today, subsection D of the zoning lot definition. But when we look at what the trial court did in Parkway Village, it really exposes the gravity of the lower court's error here, because the court found that the BSA had acted rationally, looking right at that same may or may not coincide language that was at the heart of the board's resolution that Justice Perry annulled. And so ultimately, and I think this is getting back to Justice Mazzarelli's questions, what we're dealing with is an issue of conflicting interpretations that puts us squarely into the universe of Chin versus BSA. And instead of conducting a de novo review and second guessing, trying to decide which of these interpretations the court preferred, the appropriate step would have been to defer to the BSA's expertise in looking at how these undefined land use terms of art should be applied. And again, the board's decision was eminently rational. I can go into the statutory support for that, but I'll just note that there are some key land use understandings set forth in the 1977 CPC report that provide additional evidence for why unsubdivided can mean multiple things beyond what the petitioners urge is a singular reading that must exclude the use of partial tax lots. I believe that means my time has ended?
No, you can continue, but if you're finished, you don't have to talk till the end, and you have 3 minutes reserved, and, if none of my colleagues have any questions, maybe we'll have you come back up after the petitioner speaks. Is that
Sure,
appropriate?
that's fine, Your Honor. I'll save my remaining arguments for rebuttal.
Okay. Okay, Mr. Emery, we've given you 12 minutes to respond to all of their arguments and whatever else you'd like to address.
Thank you.
Good afternoon.
Thank you, Justice Cabinet. Good afternoon. My name is Richard Emery, and I represent the Committee for Environmental Sound Development and MAS.
Counselor, why aren't the appellants right that the mootness doctrine applies to this building, which is almost completed now?
Well, for several reasons. First of all, we did everything that Dreikhausen, the Court of Appeals case that discusses this issue and that controls, requires. We made 2 preliminary injunction motions. We sought relief ultimately in this court to vacate the stay. We pursued the DOB appeal. We've pursued the BSA appeal. We pursued.
But while you were litigating the case, the building was going up, and you lost. You made a motion for a preliminary injunction, which was denied. You filed a notice of appeal, and then you didn't pursue your appeal. Now, there may be strategic reasons for that.
Well,
the building continued going up.
The reason is because the executive vice president of the development company said as follows in an affidavit twice. Once originally when we went in for the first preliminary injunction, and once the second time for the second preliminary injunction, he said, the risk of allowing the owner to proceed with construction of the project falls entirely on the owner, which willingly accepts that risk because it believes that DOB's determination that the project complies with all applicable zoning requirements is correct and should be sustained. Repeatedly, again and again, the owner asked for a decision on the merits and waived its rights. It entered into a stipulation that covered 322 days of this period. When that stipulation expired and when Justice Perry's first decision came down, their trial lawyer, Mr. Scott Mullins, said as follows, in the context of a hearing on the preliminary injunction, in order to stave off the preliminary injunction, he said, as long as you timely sought injunctive relief, no one will ever say that you waived your right. This is not a case like Dreikhausen or Weeks or City Neighbors that the other side cites. This is a case where there's judicial estoppel. We relied specifically on the statements of the owner and his lawyer.
I don't follow, because your motion for preliminary injunction was denied, and you had relief you could take, and you did not follow through with that relief. To come to this court to attempt to get that order overturned.
Dreikhausen makes very clear that that's one factor, but it is by no means the only factor. Dreikhausen makes it clear that the key is notice, and in this case, unlike Dreikhausen, unlike Weeks, unlike any of the other cases, the owner assumed all the risk for going ahead with the building. So there was no reason, it's not bound by a mootness issue because they waived mootness. Their stipulation read as follows. Their stipulation on this issue waived all equitable defenses. That would include any arguments the owner may assert relating to retroactivity, vested rights, whether common law or under the zoning rule, zoning resolution or other statutes, estoppel, mootness, latches, or other equitable defenses. They stipulated away exactly what you're saying, Justice Singh. They said, and they staved off preliminary injunction motions by doing that. There was no point. If I came up to this court, and we certainly considered coming to this court, if I came to this court, you would have said, well, they've taken the risk. There's no reason to give an injunction. It was absolutely clear. And the only reason Justice Perry didn't grant an injunction is because they entered into the stipulation. They waived their rights. Scott Mullen, their lawyer, said you don't have to do it because you've attempted to get injunctive relief. They are bound, and it's classic judicial estoppel. They took a completely inconsistent position below, and now they're trying to back away from it.
So I'm confused in the Dreikhausen case, which I have a copy of in front of me.
Yes.
You said you did exactly what they suggested you to do. So they said, you're correct, that a race to completion cannot be determinative and cannot frustrate administrative review, but courts have found several other factors. The preliminary injunction is one of them. The whether or not a party was proceeding in bad faith or without authority is another one. And whether there's some kind of novel issue or environmental concern. So I don't know really where you fit, where you fit into that.
Well, we fit into it because it doesn't apply, because they waived their right to seek Dreikhausen relief. Specifically, they waived the mootness claim in the stipulation for 322 days, and they assumed the risk at every other level throughout. They assumed the risk at the outset.
Are you saying that the waiver was for that particular time?
Yes.
Or was it for the entire time? In other words...
No, the waiver certainly was for the 322 days, during which 22 floors were built. Now they want to say that they want to build on top of the 22 floors that they waived the right to object to, which makes no sense at all. And in any event, the cutoff date is when Justice Perry decided the final decision, which is 360 days. That would be 26 floors. It's much less than half the building that was ultimately built during the period when the stipulation was not in effect. But the stipulation doesn't control here. The fact that they took the position that they were building at their own risk, and they rushed, they built on weekends, this was a rush, and they obviously had this strategic ploy in mind to come to you and say it was moot once it was built. They know perfectly well that the inertia is in favor of not taking down a building. It's a rare thing. It's happened. The Parkview case had it happen. And it's appropriate when there's an illegal permit. This case involves an illegal permit.
Oh, wait, okay, so
yes.
Stop there, because the illegal permit part is something that I raised at the beginning of counsel's argument before. They got the permit under an interpretation that had been used by the city for 40 years as to the tax lots. That's not correct?
That is not correct. The Minkin memo was a stray fact that if you do one thing in this case, I would urge you, please read the Zoltan letter to the BSA, and more importantly, the Kortler affidavit at 270 of the record. The Zoltan letter is at 120 of the record. You'll see very clearly the Minkin memo was discovered in the course of this proceeding. It had never been relied on by DOB. It had never been relied on by anyone. There have never been any partial tax lot
So
zoning.
you're saying that the city is wrong, that DOB did not historically, for this lot at issue, use partial or full tax lots?
For this lot at issue, there was a bank in 1987 when this lot was created during the condoing of Lincoln Towers. And by the way, this could happen in any other superblock. It could happen in the NYCHA superblocks. It could happen at Stuyvesant Town. It could happen at Peter Cooper. This is a truck they're trying to drive through the zoning resolution, which will make it opaque and impossible to follow where zoning lots and where development rights will then will exist for the future. But to your point, this one by the Mendicks in 1987 was a bank of development rights that they preserved for themselves with a 39-sided mess. They called it the gerrymandered lot. It was an exploitation. Nobody ever challenged it. It was used until this case because of the monstrosity that they've created. It's the biggest thing by far. It's completely out of context for the neighborhood. They have 20-foot floors and huge mechanical spaces because they know they can sell for the highest price the higher floors. And it has completely desecrated the consistency of the neighborhood. That's why this case is different. And they did use it, you're right, Justice Singh. They did use it in the past, but DOV overlooked it. And when you look at the Zoltan letter, you can see very clearly, even though they felt compelled to allow it because they had used it in the past, they said they were wrong. And they never relied on the Minkin memo. Nobody's ever relied on the Minkin memo. Moreover, we've challenged them for 3 years to show one statement anywhere in the last, since 1971 when this was put into effect. We've challenged them over and over again to come up with one commentator, one piece of evidence that whole tax lots.
But they have used it. I mean, Ms. Halligan said, and in the paper, the record reflects that there are approximately 38 buildings that have used this interpretation over the years that's been approved by the board.
It's completely incorrect. The 38 buildings, and sometimes they say 17, sometimes they say 27, sometimes they 38, many of them are pre-existing lots, pre-existing in 1961. 17 of them or so, or several of them, I'm not sure of the exact number, are from this zoning lot, which we're challenging here today. And others have all kinds of special permit issues and other issues. There's 1,700 zoning lot mergers. Not one of those has had anything but whole tax lots. Whole tax lots are the building block of a transparent system. You can't know, the community can't know, planners can't know, DOB can't know. If you read the Zoltan letter, you'll see very clearly DOB can't know, and that's why DOB came out the right way on
Counsel,
this
I have
issue.
another question. I want to go in another area.
Sure.
Because both attorneys also discussed the Parkway case, and I want to know why wouldn't that apply here when we're talking about the interpretation?
Because the Parkway case doesn't say anything about whole tax lots. It interprets 12A.
And D.
It interprets 1210A. It does discuss 1210D tangentially, but the actual lower, if you look at the lower court decision, which we attached to our brief, you'll see that it's basically a 1210A case, and it involved a pre-existing 1961 pre-existing lot. So it really has very little to do with anything other than the fact that they said the BSA interpreted the zoning regulation. But what we have here is two agencies that contradict one another. DOB says one thing, BSA says the other, and the consequence of that is What do you give deference to? Actually, Justice Perry gave deference to the BSA by sending it back, but ultimately he gave deference to the enforcement agency, which is DOB. And DOB is very clear. This is not the way that zoning is done in New York City. It provides enormous opportunities. Look at the Kortler affidavit. Enormous opportunities for mischief by developers that nobody's going to figure out in time to do anything about because it's opaque. Transparency is gone of tax lots being whole tax lots within zoning lots.
Thank you very much, Mr. Emery.
Thank you very much.
For your argument. Ms. Halligan, you have 3 minutes.
Thank you. 2 points, if I can, Your Honor. First of all, on mootness. With respect to the risk point, I am not surprised that Mr. Emery says that now, but I would point you to what he said at the time. At the time, he said that the stipulations would not protect him going forward. This was in front of Justice Perry in his briefs, in the record, because they had expired, and that is why he said to Justice Perry that if an injunction was not issued, that the ability of the BSA to evaluate this on remand would be, as his partner said, null ab initio. And so that's the answer to that question.
So you don't think there was a waiver based on the stipulation?
Absolutely not, Your Honor. We accept...
What was the purpose of the stipulation?
The stipulations covered a very discrete period. They were heavily negotiated from May of 18 until the date on which the court decided the first Article 78. And that's clear on the face of the stipulation at page 288 of the record. We're not contesting that. What we are saying, and our brief gives you the record sites for this, that the construction outside of that window was absolutely the kind of substantial completeness that the mootness doctrine is intended to get at. As for Mr. Mullen's comment, he said clearly that he needed to seek injunctive relief on a timely basis. That includes coming to this court, and there is no evidence that this building was built in a rush. Secondly, with regard to the issues around the Minkin memo and the BSA, I would say, Your Honor, that given that this is clearly a technical land use issue, I think that we should take the BSA's word for whether it applied the Minkin memo as opposed to my adversaries. With respect to Parkway, Your Honor, I think the decision speaks for itself. It clearly says that the court will defer with respect to 12A and 12D. Finally, I would, and let me also add, with regard to the lots that have permits with partial tax lots, that's set forth by the BSA, not just by us, but by the BSA in the record, and those are all delineated, including the 28 certificates of occupancy on the very block where this lot sits. Finally, I would say this. Obviously, taking down a 55-story building in the middle of the Upper West Side would inflict tremendous disruption. There is a public school that is right by, and it is as crowded a neighborhood as there is in this city. I don't know why Mr. Emery did not come to this court in a timely manner to seek injunctive relief, but he did not. And as this court held in Weeks, that means that he is complicit in the building having reached substantial completion. So the case is moot. We would ask you to vacate and to reverse and to vacate Justice Perry's order. And if for whatever reason you decide it's not moot, to vacate because he declined to defer to the BSA for the reasons that the city also identified. Thank you, Your Honor.
Thank you. Counsel?
Just briefly on the issue of mootness, Your Honors, the city was not party to any of the stipulations that petitioners entered into with the developers. And we also stand here to say that this case has become moot. And while many of the risks that have been discussed focus primarily on the financial risk that the developer may or may not have assumed through various statements, there's a real risk that the surrounding neighborhood faces if a building of this size, as my colleague said, which is next to not just occupied buildings, condominiums, but also a handful of schools, It's across the street from an urgent care center and a stone's throw from a major transportation hub at 72nd Street. So there are real risks to the community if this were to be taken down. But I also want to address a couple of misrepresentations Mr. Emery made. First, he is absolutely incorrect in the characterization of the Minkin memo. We addressed this in our reply brief. This was not a stray memorandum. And again, I'll point your honors to the Parkway Village decision, because the Minkin memo is discussed there. So once again, that is incorrect, but it also misses that the BSA didn't base its decision on the Minkin memo. The BSA undertook a de novo review of all of these issues. It looked at both the text of the zoning resolution, the fact that that may or may not language that was central to Parkway Village was also relevant here, and it looked at the other evidence. When I started before, I mentioned the CPC's guidance because these are technical land use issues. Finally, the Chapter 27 of the City Charter explains how we resolve disputes like this. It's not that DOB and the BSA are sister agencies, as Justice Perry said. That was wrong. The Charter at 666 explains that the BSA has authority to render an interpretation of these terms. And so, just as in the Parkway Village decision, where the BSA and DOB looked at zoning provision differently, the BSA had the final say. And so that's exactly what happened here. Finally, I just want to clarify one point about partial tax lot use, because there was an incorrect statement earlier. If you look at page 41 of petitioner's responsive brief, they acknowledge that partial tax lots, or this untapped development potential, can be moved around to create a zoning lot. They acknowledge that. Now, they want to say that it's only with certain zoning lots, subsection A, not other ones. There's no express prohibition on partial tax lot use in the zoning resolution. So at page 427 of the resolution, the BSA makes clear that there is no unambiguous language in the statute that prevents exactly what happened here, and that's why the BSA rendered a rational interpretation that Justice Perry was wrong to set aside.
Okay, well, thank you all very, very much for the arguments and for coming in today. Stay well. And our last case for argument today is Hedges versus Planned Security Service. Counsel, you represent whom?
Your Honor, this is Anthony DiStefano from Morrow Lowling the Party for the owner defendants.
You're for the owner defendants. Okay. You may proceed. Good afternoon.
Good afternoon. May it please the court. The owner's duty in this case was to provide minimal security precautions to protect against reasonably foreseeable criminal activity. In fact, the jury was instructed that to find the owners liable, the jury needed to determine the owner should have...
Weren't there a series of incidents that preceded this particular happening, involving things being thrown over the same walkway, and in other areas, a shopping cart being thrown down an escalator?
Right, Your Honor. So what I was going to say was that there are three types of alleged events that the plaintiff attempted to use to prove notice. The first was small objects such as candy that was thrown over the rail. Respectfully, candy is not similar to a shopping cart. There's nothing that throwing candy would have done to make us foresee that ultimately...
Well, it shows you that that type of activity is being engaged in, throwing things over that particular area.
The type of activity that was described as littering, not a criminal activity of an assault by shopping cart, Your Honor. So again, the only foreseeability, the only event that they could have tied to foreseeability was the alleged event involving Bob's shopping cart that happened about 9 months earlier. So in that regard, they had a witness who was supposed to provide the smoking gun testimony, Mr. Rodriguez. He was supposed to come in and testify that security was called to the fourth floor walkway and that they escorted the boys out with the shopping cart. 5 pages is the sum total of his testimony on direct examination and a 3,500-page transcript. This is supposed to be where the smoking gun is, and it's not there. He never testifies that security was called. He testifies that security happened to come onto the scene as things were happening, and he was supposed to testify that they escorted the 2 boys away with the shopping cart. He never said that. In fact, he testifies security was never called, and he never called the police. He testified that he never participated in a conversation with security to know whether or not security knew that the cart was involved in an incident, that the cart could potentially have been thrown over the 4th floor railing. The presumption, of course, was supposed to always be that if security were called and security knew about the cart, they would have documented that in a report, they would have followed up with an incident report, and both of those would have made their way to the owner defendants, putting them on notice. Even their expert concedes that based on the testimony, it's reasonable to assume that the owner defendants were never made aware of that incident 9 months earlier. So if we're not aware of an incident, Your Honor, then how can we possibly take any steps to prevent a future incident from occurring? And the only other way that they could have tried to establish liability against us would be through the use of their expert. But their expert candidly admitted the last question that he answered on cross-examination was, I don't care what the defendants did, they're automatically liable. I am holding them to a standard that is greater than the legal standard. Again, we are only supposed to provide minimal security, not optimal, and the law is clear on that. Yet the witness for the plaintiff testified that he basically made us the guarantor of safety of every individual at that premises, and that's the wrong standard. So for that reason, the expert also failed to satisfy any burden on liability against us. Assuming that they were able to overcome that hurdle, Your Honors, then the next question is, well, apportionment. So here they put 90% on the combined owners and security, plant security here. And as this court is aware from its decision in Nash versus Port Authority, and also
Counsel, is Nash the same case as our case here?
No, Your Honor, it's not.
I mean, aren't they, would you agree that they're diametrically opposed in terms of what happened at Nash, a conspiracy, an international conspiracy maybe, versus, in this case, 2 impulsive boys involved in criminal mischief?
Yes, Your Honor. In that sense, they are diametrically opposed. I apologize. It's a difficult word to say, especially through a mask. But in the sense that viewing the conduct of the owners, if I'm standing in the owner's shoes in these cases, the owners in Nash were specifically told not only that it was foreseeable that an activity could occur, a criminal activity could occur in their building, they were told precisely how it could occur. And they made the conscious decision to forgo taking any security measures to prevent it because they were concerned about revenue. So for that reason, their behavior was much more egregious than anything that the owners did or did not do in this case. And same in the Granada case, the city of White Plains. 350 incidents had occurred in the year leading up to the poor death of Mr. Cone, and they did nothing. They had only cameras in the parking lot that were not even being monitored. They had nobody walking around the building. The criminal who committed the murder was able to stand around in front of the elevators for over an hour and nobody did anything about it, even though he was known to people in that building to be a criminal. So again, it distinguishes us from them and says that the 65% in those cases could not be on us, and we have to be much lower. And just quickly, because I see that my light is on and I do want to get to damages, with regard to the 2 12-year-old boys, we cited the case of the 14-year-old boy who was found 50% responsible for his conduct in the subway, and he was struck by a train. Age should not matter here. When you look at the video, you see that the 2 boys, one of them looks over the rail before they throw the cart. If you look at the other video, you can see that Mrs. Hedges was actually down there at that same time. So there's a presumption that he saw her there and went through this act anyway. The cart got hung up on the rail, and instead of continuing to run away, their immediate reaction is to go back and make sure the cart goes over the rail. So for that reason, 10% is far too low. With regard to damages, this court in Donlin said that we look to analogous cases to find benchmarks to determine whether or not pain and suffering is...
Well, of course, I mean, it's tough to find analogous cases. I mean, they all are a little bit different, but if you have some, I mean, we've looked at a lot of them.
Correct, Your Honor. A half a dozen cases involving traumatic brain injuries. Like you said, it's difficult to find analogous because some are younger plaintiffs, some are plaintiffs of around the same age but with worse injuries. But the range is about 2.5 to 5 million total pain and suffering. Here we have 3 million past that's currently constituted, 14.5 million future, that's 17.5 million. Clearly, this deviates materially from reasonable compensation. What the plaintiffs offered you were a handful of cases involving Pete, which I was one of the attorneys on, was a horrific case involving burn injuries, 50% of the plaintiff's body, where he was running downstairs on fire. He said he wouldn't stop, drop, and roll because he felt if he did, he was going to die. They gave you quadriplegic cases involving Barnhart versus Cybex, 2 paraplegic cases, Baraglia and Bissell, and then an amputee case at Aguilar. And for those reasons, those cases are not the type of analogous cases. And I'll reserve the rest of my time for rebuttal. Thank you.
Okay, thank you very much.
Good afternoon, Your Honors. May it please the Court, Scott Horn, counsel representing the Defendant Plan Security Service in this matter. It's our contention, Your Honor, that the lower court erred in awarding to the owner full contractual indemnification for its own negligence in the maintenance and operation of its shopping mall. We submit that reversal on this claim, which represents a $27 million loss transfer, is warranted for 3 reasons. First, the indemnification provision does not evince an unmistakable intent to indemnify the owner for its own negligence in failing to undertake the 5 remedial measures on which plaintiff's claim was based.
What section of the GOL are you relying on?
Secondly, Your Honor, under the GOL,
What section are you relying on?
5-322.1, this is an alternative.
That applies to construction, correct?
I'm sorry, Your Honor?
That applies to construction?
Construction and maintenance, Your Honor. That's correct.
And this is a security agreement?
This was a security agreement.
How does it apply?
I'm sorry, Your Honor?
How does it apply? Sorry.
Well, our position in the alternative is that this provision should apply because it does involve the duty to maintain the premises in a reasonably safe condition. As we pointed out in our brief, this appears to be a novel issue of first impression. The only case that's come up that we've seen thus far was a lower court case which determined that the GOL did not apply, but on substantially different grounds. So if you look at this context and the 5 remedial measures that the landlord ultimately failed to undertake, these measures are focused on the premises and the physical structure of the premises. And the theory under which the landlord was held liable was that you did not raise the railings, move the parking kiosk, hang signage, things of that nature. So we submit under the circumstances, it's not such a clean-cut analysis on is it maintenance, is it construction, it's more what is the circumstance here. And here the theory of liability was clearly geared towards the maintenance of the shopping mall. So we submit in the alternative, assuming that the court finds that there's an unmistakable intent to cover this type of accident, that the GOL would apply, and under the circumstances it would void the agreement. But if I could just jump back to the unmistakable intent, this is a critical issue in this context because, as I said, we're talking about a loss transfer of $27 million. And what we need to do when we look at this is ultimately we need to juxtapose the language in the indemnification provision with the theory under which the plaintiff's claim was offered. And in this case, the indemnification provision is clear that the indemnification is intended to only be within the scope of the service. And service is a very important term in this context because service is defined in the contract. And when you look at the contract, specifically page 2485 of the record, it's Schedule A, that's where the concept of service is laid out by the parties. And when you look at 2485...
What other theory is there other than your security services against your client?
Well, against my client, it's a common law theory that was offered by the plaintiff. So, that's part of the disconnect in this case. By erroneously determining this issue as a matter of law before trial, you have, on one hand, indemnification, which is governed by the contract, but on the other hand, you have a trial that's offered on theories of common law negligence. So the plaintiff's theory, and this is at pages 8925 and 8930 of the record, the plaintiff's theory against my client was that we should have made a recommendation to the owner. And that's all well and good if you wanted to bring in an expert to say, well, that's what should have been done. But the fact of the matter is that was not part of the services that we were hired to perform. Again, indemnification relates to services. It's contractual. It has to be interpreted strictly. And we respectfully submit that when you juxtapose the nature of the claims at trial offered by the plaintiff against the owner with our services, it's clear that there's no unmistakable intent to cover this type of claim. So we've cited to several cases in support of this concept, the Putter case, the Suazo case, and these cases stand for the proposition that unmistakable intent not only applies to whether or not you intend indemnification, but also the scope of the indemnification. And it's that scope that this court, we respectfully submit, should be focused on. And it's that scope where the juxtaposition between the contractual definition of services incorporated into the indemnification provision stands in stark contrast to the nature of the claims offered against the defendant. Failure to raise rails, we didn't have the power to do that. Failure to hang signs, we didn't have the power to do that.
So
failure to move a kiosk.
Are you claiming that there is no action on your part for which, that you should be providing no indemnification for them at all?
That's exactly correct, Your Honor, because the services are what define indemnification. So the services are manpower, observe, and report. That's it. That's all we were hired to do. We weren't hired to formulate a plan. In fact, the plan was already formulated before we came on the scene.
On the day of the incident, weren't you understaffed? Isn't part of any security company's obligation in these circumstances, if there's an incident going on, such as this one, to have prevented such an incident, or at least attempted to?
Our services, Your Honor, if I'm understanding you correctly, are to observe and report. Yes.
And not to intercede and stop any such activities?
Well, that may be if somebody was there on the scene and failed to do so, but that's not the nature of the claim here. That's not what happened.
Isn't there a claim here that you were understaffed on that day?
There was no claim. Well, okay. So there is an argument in that regard. I submit that's a false construct. So the reality is that the 4 security guards were present there that day, the defendant's own expert. If I may just finish answering this question, Your Honor. Thank you. So the 4 security guards were there that day. The owner attempts to create an issue by saying a supervisor was not there at the time and was supposed to be there at the time. This we submit as a false construct. The reason for that is, again, we have to look at the contract. The contract at page 2483 specifically states that the supervisor is only supposed to be on site until 5 p.m. This incident occurred at 5:47. The construct that the owner is seeking to create comes from Exhibit B, which is at page 7593 of the record. However, there's testimony specific to that exhibit that says that schedule applied to one day, 5 weeks prior to the accident, and that's all it pertained to. If there are no further questions, I'll rely on my brief and reserve my rebuttal time.
Yeah, you have a few minutes for rebuttal. Okay. Mr. Geyer, you have 12 minutes, okay?
Thank you, Judge. May it please the Court, my name is Matt Geyer. I represent the plaintiff's respondents. Your Honors, I don't think there's any serious question but that there's more than legally sufficient evidence to sustain the liability of the owners in this case. We have multiple documented reports in their possession of objects being thrown by kids from the upper levels of the mall.
What kind of objects? Because your adversaries said
He had rock
candy
struts,
wrappers.
We had garbage, we had cans, we had a juice thrown down at a customer, and we had a shopping cart thrown down an escalator, Judge. We also had an eyewitness in January of 2011 or February of 2011 who stopped them from throwing a shopping cart in the same exact location. And yes, security came and took him away. It didn't happen an hour later. It didn't happen a half hour later. Security came and took him away. They're looking for the benefit of every inference they could possibly get to assume that security took these kids away for no good reason. This is unequivocal evidence. We have Mr. Robles, who testified. Mr. Robles, who was there twice a week from 2009 till the day this happened in October of 2011. He said every time he was there, he said he saw literally hundreds of occasions of debris being rained down from kids throwing it from the upper levels. There's not just actual notice, which there is, there's constructive notice. You can't have this kind of conduct going on. He said bottles come smashing down, book bags being thrown. He got hit by candy. They think candy's no big deal. He got hit by it. He went to the office, not of security, but of the mall management and complained about it. What they had there, they invite people into the public. They have known evidence of a regular daily occurrence of kids throwing down objects, and they do absolutely nothing to prevent it, Judge. Absolutely nothing. And that is gross indifference. That's not just negligence. That's gross indifference to the safety and well-being of customers at this facility. And you can take the testimony. By the way, they say there were no similar instances. You know, on the report of the day at issue, they put down similar instances, and they describe it as prior similar instances, quote, and paren. This is their own report. Items being thrown from elevated walkways to other areas, or other areas. They say none. Mr. Classy, the ERP manager, his employee says that was incorrect where they said none. That means all these things that they have are evidence of similar instances. So there's clearly more than enough notice in this case. And Mr. Classy and Mr. Blumenfeld both admitted if these things were happening, there had to be a plan to remedy it, a plan to intervene to stop it. Mr. Uliano from the security company said the same thing. Then you get to my expert, and they tell you these horrible things, that he's bad. You know what? All he said is the same thing they said. And he didn't.
What about planned security's responsibility? And in terms of what Mr. Horn just argued when he was up here, what's the liability against them and the
We've already settled with
indemnification?
them, so I don't have an axe to grind with them right now.
Oh.
But they provided the manpower for security here. The owners, they had control over it. They had their own security consultant, some guy named Patterson, who was sitting in the meetings, reviewing the reports. They got these reports. There's no question about that. There's no question that if security took these kids away, there would be an incident report, and there would be something in the logs. They didn't produce it. We had these statements from Rodriguez in December of 2011, long before we filed this case, from Robles in January of 2012, long before we filed this case. And Rodriguez said this happened in January, February. They produced nothing from them. Nothing. That's why there was properly a missing documents charge. And for many, many more documents they didn't produce too, 40 days after March of 2011. But, I mean, I don't think there's any question. Mr. Hudak, their own expert, admitted when they first started here, it was sufficient security, then things changed. You have these reports. You had to put people over the bridges. Mr. Villani, the plant securities expert, said it's literally shameful what they did. Talking about the owners. Now, onto apportionment.
Yeah, okay.
All right. Between plant security, I'll rely on my brief for that, between plant security and the owners, 65-25. But the kids, these 12-year-old kids, right, Nash.
It is
Judge,
a criminal
I understand
act,
that you say Nash is different.
Nash
is different in that terrorists were given 32%, where the owner that ignored the warnings that there would be terrorism was given 68%. Here the owner has 65%. Grenada, also, the owner 65%. The murderer, adult, 35%. Here are these kids, sure, they're kids. That's a big part of it. But here's the deal. It's not just that they're kids. Every one of these reports, everything that Rodriguez testified to and Robles testified to, it was all kids. They're doing what all the other kids at this place are doing. There's a school around the corner. Kids are coming after school, going to East River Plaza, and when they get bored, they're throwing stuff down from the upper levels. There's adults in charge here. The owners, they had notice, tons of notice, they did nothing. You know, that alone is enough to justify the apportionment of this case. But on reply, they come back to us and they say, you know, Nash was so bad, and the owners there, and Granada was so bad, that it would have, if they weren't municipalities, they'd be liable for punitive damages. You know what? I agree with that. But the same thing applies here. These people would be liable for punitive damage. They knew of a recurrent hazardous condition going on regularly at their facility, and they did nothing. That is gross indifference to the safety of the customers. It would make them liable for punitive damages. We didn't claim it here because we have severe damages in our own right. We didn't need punitive damages.
So you
But it certainly supports the apportionment in this case.
Okay, you want to go to the damages now?
I would love to, Judge.
Thanks.
They're trying to tell you this is a TBI case, okay? This is not a TBI case. TBI is traumatic brain injury. Now, there's all kinds of traumatic brain injury. And you get shot in the head, you get hit with a sledgehammer, you fall down the stairs, and you get a subdural hematoma. That's all traumatic brain injury. But that's not what they're talking about. That's not the TBI they're talking about. That's not the cases they cited. And do you know Godfrey or Ashkenazi? Those cases are, what happens is when you get hit, like the woman in Godfrey, and she hit her head on the partition, went to the hospital, saw a doctor a week later, okay? It's like a whiplash injury. It doesn't create any damage to the structural matter of the brain. It's axonal shearing, which shears the nerves. But has neurologic impact for sure. Nothing like the kind of devastating damage when you destroy the matter of the brain. And that's what happened here. This is not a TBI case. In Ashkenazi, the dentist case, the guy who fell off his moped went to the hospital, was admitted overnight, released the next day with a diagnosis of a concussion. 4 days later, he went to the site where he fell to take pictures. You know where Marion Hedges was 4 days after this incident? She was in the hospital in a medically induced coma fighting for her life. And she was fighting for her life because she was practically dead, but for the good graces of Dr. Patel having been there and brought her back to life because her heart had stopped. Her heart stopped not because it hit her in the heart. The car hit her in the head. The insult to her brain caused her heart to stop. She was taken to the hospital. They do medical pictures. She has 6 broken vertebrae, fractured vertebrae, which cause her pain till this day. Pain on her right side, pain when she walks. Her husband can't touch her. Forget about the other stuff, the scapula and the spleen. Nobody cares about that. Fractured vertebrae and severe brain damage. Numerous bleeds in her brain.
So what would you analogize this case to? Are there cases that would give us a basis to...
I would analogize to any case where you have a plaintiff whose life was ruined by a severe injury. And that's why I cited to the Pete case, and that's why Judge St. George cited to the Pete case. Somebody whose life was ruined by this injury. Her life was ruined. Again, I want to emphasize the structural brain damage to the frontal lobe, the brainstem, the parietal lobe, the temporal lobe, the ventricles. All, when you have that kind of bleeding, destroys brain tissue. And she had a lot of it, particularly in the frontal lobe. Okay? And the impact of this, you can hear from a friend who testified, Suan Wang, general counsel of Sumitomo Bank. She says she's not used to doing things like this. She doesn't come in on things like this. She's a corporate lawyer, but lives are at stake here, she says. She analogized Marion before the injury to a beautiful mermaid. Now she's like her 88-year-old mother. You want to find out what Marion was like before this? We have in the supplemental record a video before she was injured. She was pulled off the street by the producers of Regis and Kelly. They had her spontaneously come in and go on the stage. Just see the grace, the poise, the wit she displayed. She blew them away. That woman is gone. Now what she's got, constant pain from the fractured vertebrae. She can't function on her own. She depends on others. She has poor balance and no coordination. She can barely walk. She often falls. Double vision, poor judgment. She can't make decisions. She has no memory. She can't think, process. She can't even do math above a second grade level. And she's incontinent. She's talking about Mrs. Wang talked about how they were walking back from lunch together. A couple of blocks would take a few minutes, took a half an hour. Yes, because she's got the back pain, because she can't see, she has double vision because of the coordination. But as Mrs. Hedges testified, it was because there was something else going on. She was doing a number 2 in her pants. She says this. And she says, I can't tell Sue on this. I disgust myself. I disgust myself, and I don't want her to be disgusted. And she hit on this theme later when just read her testimony, and they say it doesn't show she's cognitively impaired. She goes on, she meanders, she's all over the place. But she has some poignant moments. She talks about her relationship with her husband and how she disgusts herself. And this is what this case is about. Her life is ruined. And I think Judge St. George, I think she pained over coming, they awarded $6 million for past, $29 million for future for 29 years. I think she pained very hard to get to a number that this court would find does not materially deviate from reasonable compensation. But at the same time, compensating this woman with a ruined life who she saw in her court every day for 3 weeks. And she came to a number of $17.5 million. She cited the Pete case. Pete was $16 million 7 years ago. And his life was ruined for sure.
That's second and third degree burns, right? Over 50.
Sure, second and third degree burns will ruin your life. You know what? Maybe second won't, but third certainly will ruin your life. I agree with that. Okay? But that's
Don't
what
you think it makes more sense to look at cases with brain injury instead?
So the cases they cite with brain injury are the amorphous brain injury, the TBI that we talked about, the axonal shearing.
You're saying this
She has big chunks of her brain gone. It's a different kind of a brain injury, and this most definitely did ruin her life. You could just read it. That's what Mrs. Wang said. This ruined her life. And so if you throw Pete, the number in Pete, $16 million, into an inflation calculator in 2013, you know what you come up with today? And I did it in 2 different inflation calculators, identical, $17.88 million. So I think Justice St. George hit the nail right on the head in terms of the exact amount. And if anything, I think she cut a little too much from past pain and suffering, but there is no reason to reduce this, not based upon what she had to go through. Now, I know my time is up. I did have other items of damage I would discuss, but if the court says
does anyone have any further questions? Okay, I think we will take a further look at all of these things. Thank you very much, counsel.
Thank you, Judge.
So I'll just start working backwards from what I just heard. Judge St. George did not engage in any analysis. Respectfully to Judge St. George, she cut the numbers in half, literally cut the numbers in half. We'll put that aside for a second.
I don't want to say she didn't. I'm sure she did some kind of analysis. That's where she came out to. I don't want to say that about my colleague.
I did not mean to.
Can you talk to me a little bit about the indemnification issue?
Yes, Judge. I will, just one more second. I just wanted to say Ashkenazi, unable to button his shirt, unable to wash himself, cervical herniation, radiating pain, disabling pain, damage to the frontal lobe of his brain. I mean, I'm hearing the exact same thing, $5 million. Okay. On indemnity, with regard to plan security, the language of the contract says that they'll indemnify us from any and all claims, which we know from Levine is the triggering language that would include even for our own negligence, Levine versus Shell Oil from the Court of Appeals, directly or indirectly arising out of the performance of the services. And you'll recall from the transcript that a big deal was made about, well, services with a capital S has some meaning. So let's look at what the meaning is. Take all measures reasonably necessary to ensure the safety of visitors to the property, right? That's number one. That's exactly what happened here, right? They didn't do that. Number two, if they represented and warranted that they will continue to be aware of criminal activity in the vicinity and then modify its level of services consistent with that. So if all of this stuff is raining down from the floor walkway and the daily reports are showing that and Planned is aware of that and they haven't done anything to modify their services, that's exactly what they were entitled, that's exactly what we're...
But they're saying they were just hired to have people walking around and checking on things. I mean, shouldn't you as the owner have known, and you were the ones that had the ability to actually make changes to put up fences higher or do something? You had the ability to do it. They couldn't make those changes.
Right, so let's talk about the property, right? Because that was the other part of Mr. Van Horn's argument, was about how the property was, that things to do to the property shouldn't be their responsibility, and therefore they shouldn't be obligated to indemnify us for that. Well, I read it was directly or indirectly arising out of their services. So even if it indirectly arises out of the services, they're still obligated to indemnify us. But what he's appealing is, yes, a summary judgment determination, but then we get to a trial. And at trial, he has the opportunity to have the jury answer those questions. Were you finding the owners liable for failing to increase the rail? Were you finding the owners liable for failing to put up signs? Were you finding the owners liable for failing to move the kiosk? They didn't ask any of those questions. The jury could just as easily have found us liable because of everything that Planned failed to do, but felt we were ultimately responsible for, because, again, the law is that the owner has the obligation to provide the minimal security. So the jury is looking at us saying, you failed to do that because you hired an incompetent service agency that didn't do what they were supposed to do. And for that reason, it still could, they had the opportunity to fix something that they didn't do. Let's see, I know my light is on, but real quick.
Yes.
Understaffed, we weren't able to explore that. Chad Burton gave a statement. He said that he should have been on that shift that night. He would have been on until 6:30, but he wasn't there because he called in sick and nobody covered that for him. We weren't able to go into it. The statement actually continues on that that schedule would have maintained, it wasn't just for a day, it would have stayed in effect until the next schedule was put in place. So he would have been there that night. Let's see. There's no good reason. The assertion that there was no good reason for security to be there. Well, Mr. Ramirez, who is Mr. Rodriguez's coworker at the Bob's store, testified that anytime security was called, it was about kids throwing candy. So again, we have the situation where kids are throwing candy, and that's not throwing a shopping cart.
Okay, it's kind of late, so I thank you very much. Mr. Horn, you have a few minutes.
Thank you, Your Honors. Very quickly.
Sure.
On the issue of our services, I would refer the court to page 2485, which outlines our services. The services are, you heard the plaintiff's counsel just mention it before, to provide the manpower that was required under the owner's pre-existing security plan, and to observe and report, fill out the reports that ultimately the plaintiff used to establish foreseeability and notice. That was done. That was the nature of our role at the premises. Juxtapose that with contractual indemnification. So when you say that the indemnification has to directly or indirectly arise from the services, that doesn't mean that we are responsible for anything that happens on the premises, whether it's raising the railings, moving a kiosk, hanging a sign, putting surveillance cameras in, whatever the owner should have done. That's not observe and report, and that's not manpower. And as the case was processed through verdict, the plaintiff put in all of these common law theories of liability. And it wasn't incumbent upon me, my client or anyone else to determine what should or should not have been found by Judge St. George on an indemnification summary judgment motion that was rendered a year or two earlier. The fact of the matter is the common law claims all refer to obligations that the landowner had in maintaining and operating its mall. Lastly, with regard to the supervisor who allegedly didn't show up, again, I just want to stress the statement that was just referred to was not admitted into evidence. The entire construct is this schedule that appears in the record, and that simply says, it's page 8645, that on one day, 5 weeks earlier, the site supervisor was going to be there until 6:30. But if you look at the contract, Your Honors, the contract is clear, and that's at page 2483. The supervisor's only supposed to be on site until 5 o'clock. The incident occurred at 5:47. There is no failure to show up. There is no short staffing. And if you look at these page references that I just provided, and in addition, the defendant's own expert acknowledging that there was no short staffing, that's at page 69, 68 in the record, you'll see this is completely a red herring. The fact of the matter is the plaintiff offered 5 distinct theories of liability to the jury. That's what their responsibility was based upon. None of them pertain to the provision of manpower or our obligation, our service to observe and report. And so under the circumstances, Your Honor, when you juxtapose the difference between the common law and the contractual obligation under indemnification, we submit that the lower court erred in awarding indemnification full for their negligence as a matter of law. It should be reversed. Thank you, Your Honors.
Thank you all very, very much. Have a nice day.
Thank you. You as well.